Good morning. Thank you for being here, and thanks for the people that are watching on the video feed. We were expecting Chris Cox to kick us off this morning and talk about the importance of Section 230, and unfortunately, he has come down with COVID. And we talked about doing a couple other ways to bring him in, and I said, for me, Chris is a national treasure. Let's just leave him alone. let's let him heal, and I'm sure we'll have other opportunities for him to speak about this. So I was watching another think tanks event a couple of weeks ago, and they never started out by explaining what Section 230 was, and I think all of us in the room probably have a pretty good idea. But since in Chris's absence, I'm just going to take a moment and talk about the origins, the genesis of Section 230, just to talk about and then lay out how the day is going to go. So Section 230 was enacted as a part of the Communications Decency Act, which was a section of the Telecommunications Act of 1996. What it's known for is the immunity for online computer services as a respect for third-party content that is generated by users. So Section 230 was developed in response to a pair of lawsuits that I cannot tell the story and give it justice. At some point, I would suggest that you hear either Chris or Steve Del Bianco, who's in the room, talk about the Wolf of Wall Street and the things that happened with when we remember Prodigy and CompuServe, and how Chris Cox and now Senator Wyden realized that we needed to give some immunity to these nascent resources to allow the very beginning of the internet to come about. And part of that was they wanted to interpret that these service providers would be treated as publishers, or should they be treated as distributors? And we really there weren't that many people on the internet that we had to figure this out. So the two sponsors of this legislation, Representative Cox and Senator Wyden, believe that interactive computer services should be treated as distributors, and they should not be liable for the content they distribute as a mean to protect the growing internet at the time. And I think that simplicity, and I actually went and printed out the law. I haven't done that in quite some time, and it's 4 pages. And I know a lot of us are used to like 100-page bills, so it's kind of surprising how they really boiled this down to the essence. But at its core, the immunity comes down to 2 things, and in my head, I always make it really simple, which is C1, you leave it up, C2, you take it down. So Section 230 C1 provides immunity for liability providers if they using an interactive computer service, which you'll hear about a little bit today, to publish information, again, provided by third-party users. These are not they're not talking about the content that they're putting up themselves, but people that are making comments. No provider or user of an interactive computer service shall be treated as a publisher or speaker on any information provided by any other information contender. That's a really important point, and you're going to hear a lot about that today as we talk about the Supreme Court cases that have recently been heard. Section 230C2, or the take it down part, further provides for what they call a good Samaritan protection for civil liability for operating interactive computer services. So it's a good faith removal of moderating third-party material deemed obscene, lewd, anything that's excessive, violent, harassing, or otherwise objectionable content. And a lot of times the good Samaritan part of it is not nearly as discussed, the C2 as C1 is. So after the passage of the Telecommunications Act, this is where it gets a little confusing. Is it was part of the Communications Decency Act was challenged by the courts, but the courts decided that while parts of CDA were unconstitutional, they believed it was important to keep 230 in place. So they severed it out and kept it as part of the Telecommunications Act, and that has continued to be the base of why we are able to do a lot of the things that we do on today's internet. So there are exceptions, and the third panel will be spending some time talking about this. Section 230 protections do not require removal of illegal material unless they are, they require a removal of illegal material in the federal level. So you don't get away with saying 230, it doesn't matter, it gets to stay up. There's also, very early on, they decided we needed to protect intellectual property. We have the DMCA and copyright, which we'll be discussing. There's the element of federal criminal prosecution, which has become more prevalent lately. The Communications Privacy, or ECPA as we know it, and then there was a recent amendment on sex trafficking known as FOSTA. So with Chris Cox and Ron Wyden wanting to help the growth in the internet of online services, there's been a lot of discussion in this area. And so our first panel today is going to discuss the challenges this law has been having. And we have the two particular Supreme Court cases on Gonzalez versus Google and Tamna versus Twitter. The second panel is going to discuss the economic ramifications if we were to lose Section 230 and the cost that it takes to go to court, especially if you are a developing website and not one of the larger companies. The third panel will discuss how to manage problems that the critics say Section 230 enables, which are some of the things I've just mentioned: the spread of harmful and illegal content, such as hate speech, terrorism, propaganda, misinformation, and the really core one, I think, is the continued confusion between the First Amendment and Section 230. So that is our goal for today. Kind of the why now is because this topic's been discussed more than ever. We do have a program here at AEI that is on content that we've been running for about a year and a half. Highly recommend you go take a look at the website. Part of that, and you're going to see on the first panel here, the author who took the time to do summaries of all the amicus briefs for Google versus Gonzalez. So that is a really amazing asset and tool for the Supreme Court work. We also have a lot of different areas of Congress that are trying to claim jurisdiction in this area, and we'll be discussing that on several of the panels, as well as the fact that we have a lot of tech companies that are looking for clarity, not only here in the United States, but the United States has always been the lead in this, and there are a lot of other governments that are watching what is going on to see if they can tear down some of the freedom of expression that we have allowed for the internet, or just completely turn the internet off in their countries. So we need to be very careful how we manage this, not only as the United States, but looking, because the globe is looking to see what we're up to. So with that, I'm going to turn this over to Ari in the first panel discussion.
Good morning. Thanks for being here. I am going to just do a brief introduction to our esteemed panelists. Immediately to my right is Clay Calvert, who is a professor of law and the Brechner Eminent Scholar Emeritus and former director of the Marion Brechner First Amendment Project at the University of Florida. Next to him is Kate Ruan, the Cy Sims Director of U.S. Free Expression Programs at PEN America, and Samir Jain, Vice President of Policy at the Center for Democracy and Technology. So we're at a really interesting point in internet history with the Supreme Court more than 25 years after Section 230 was first passed, taking its first cases. Up until this point, the Section 230 jurisprudence has been relatively stable. Claims brought against platforms for the content that they host have been rejected, and attempts to evade Section 230 and sue platforms for taking content down have also largely failed. And now we are staring down the barrel of who knows what. Gonzalez and its sister case, Tamna, are cases that arose under the Anti-Terrorism Act, which establishes liability for knowingly aiding and abetting acts of international terrorism. The facts are terrible. Everyone acknowledges that. And the plaintiffs are the families of victims of these attacks. The claim, the basic claim of the plaintiffs is that the extremist content on YouTube, for example, is algorithmically promoted by the platform, specifically via up next or related content type of tools. And the Ninth Circuit rejected these claims under Section 230C1 because they sought to treat Google as the publisher of information provided by a third party. There wasn't really a circuit split. The Second Circuit had reached a very similar conclusion, or the same conclusion in a very similar case out of New York. So the Supreme Court didn't have to take it, but it did. So I want to lead off, I guess, with the easiest question, which if answered properly will let us all go home right now. Did this need to be a Section 230 case? Does it need to be a Section 230 case?
As you noted, in addition to Gonzalez, there's a second case up there, which is Twitter versus Tamna. And that is presented not as a Section 230 case, but a case about a question about liability directly under the Anti-Terrorism Act, and in particular whether or not Twitter can be held liable for aiding and abetting an act of international terrorism. I think there are good arguments that, even if you leave aside Section 230, that at least on the facts of these cases in which there's no allegation, for example, that the attacks at issue were planned or even discussed on the platforms, or even that those who were involved in the attacks ever used the platforms, I think there are good arguments that there's very little to show any kind of causation and other elements of the cause of action. So in theory, and Justice Barrett alluded to this, I think, during the arguments, one way the Supreme Court could decide these cases is to say, at least on the facts of these cases, there's no potential for liability directly under the Anti-Terrorism Act, and therefore we don't even need to reach the question of whether Section 230 would bar liability.
That being said, I will say, to answer your question directly, yes, it did need to be a Section 230 case. Samir is absolutely right that the underlying cause of action could decide this case properly in favor of Google, assuming that Google did not know is probably what the court will come to, something along those lines. But this really needed to be a Section 230 case because the whole point of Section 230 is you're not supposed to get to the merits. You're supposed to decide when a cause of action attempts to treat an interactive computer service provider as a publisher, that Section 230, generally speaking, bars liability unless the interactive computer service provider has done something to contribute to what made the content or the activity involved illegal. So this really did need to be a Section 230 case, in my view.
And I think that's why it's so important, because you cut off the case right there with Section 230, and therefore you avoid all the litigation costs and the expenses that go with that. So indeed, it's really that two steps, right? Is it a Section 230? If that blocks it, we end it there, and we don't even get to the substantive merits of the underlying cause of action. And again, because litigation costs are so prohibitive, that's why Section 230 is so key here, I think.
Right, and that, well, you guys really did a good job of foreshadowing my next question of.
Can we go? Can we go now? We were done? Okay.
Is that it?
Well, Kate kind of ruined it for us, so it needs to be a Section 230 case, so we all have to
Sorry.
stay. Broadly speaking, what's at stake here with the Supreme Court's decision? I know that's a very broad question, but if you could distill it.
I mean, to me, the key policy what's at issue is users' ability to speak and users' free expression rights online. Because as Clay alluded to, the reason that the litigation costs matter a lot is that if platforms realistically face the prospect of those substantial litigation costs, leaving even aside liability, then their rational incentives are every time there's a complaint or allegation that a particular piece of content is unlawful, their rational response in many cases is going to be to take that content down. And that's going to be particularly true of controversial content for marginalized communities. You're going to create a heckler's veto on the internet. And so that, and it's really the litigation costs that Section 230 insulates the providers from that remove a lot of that incentive. And so if the court were to narrow substantially Section 230 immunity in a way that gave rise to a real risk of liability for content, third-party content, then I fear that the result is that you have less ability for users to speak online and to express themselves. And to me, that's really what's at stake in this case.
I couldn't agree with Samir more. The only thing that I would say to add to that is the difference between Section 230 and the First Amendment in this particular context. That Section 230 creates the structure that allows freedom of expression for users on the internet. And without it, we are left with the First Amendment, but having to continuously fight lawsuits over and over and over again will chill speech on the internet. So I do think that's a big part of what's at stake here. And the attempt to parse the difference in Gonzalez anyway between what being liable for recommending content versus being liable for just allowing it on your service is a distinction, I think, without a difference in a lot of circumstances. I'm really hoping that if the court does reach the merits and does decide this case, that they make clear that there could be circumstances in which the automated recommendation of content might have some liability for the platforms, but when that liability is actually founded on the content itself, Section 230 should step in and provide a bar.
And just to reiterate the point about self-censorship and the chilling effect, really, that's what we're dealing with there. And to Samir's point, it's all minority communities and other groups. So to the extent this has been framed as a big tech kind of case, I think that's off base. Going through all of the amicus brief, it affects far more than just big tech. And I think that was obviously the headline grabber. And people say, oh, big tech. Anytime you see big, it's always bad. Big pharma, big whatever. But I think, we got to focus more that this protects everybody out there, right? No matter large or small platforms.
I used to work for the Wikimedia Foundation, and I can say absolutely that's the case. Wikimedia filed a brief in support of Google for precisely this reason, because the internet isn't only those big companies. It is comprised of lots of weird, excellent services that we all use every day that need 230 far, far more than Google ever will.
So to kind of combine things that Clay and Kate both said, the crux of the issue really is, does the plaintiff's claim treat an interactive computer service, nobody doubts that YouTube is that, as the publisher of information provided by a third party? So those last two things are really kind of what the court had to deal with in the arguments. And the case, as Clay noted, attracted briefs from far-flung corners of the universe, and a lot of them all offering different approaches that the court could take, or asking the court to do various things and reinterpreting 230. So since 1997, in the Zarin case, C1 has been held to immunize traditional editorial functions, whether to publish, withdraw, postpone, or alter content. And that's been a very broad protection. But some of these briefs, and I believe the petitioner's brief too, argued that the word publish has a specific legal meaning that is different from the common understanding of publish, and that it should be restricted to defamation only and defamation-like claims. What do you think of this argument? Why is it wrong or right?
Well, I mean, the difference that you're talking about and that the argument was is in defamation law, typically you have, as Shane mentioned, the difference between distributors and publishers, and only the publisher is typically liable in defamation law, not the bookseller or the newsstand, because it wouldn't be fair to the guy who sells the newspaper on the corner. Nobody does that anymore, but if they did, or the bookseller who sells a book that has defamatory content in there. So that difference between who's a publisher and who's a distributor, and I think the argument that some are making is that C1 was very narrowly limited only to defamation, and I think no court has really landed on that point. In other words, we would roll back a lot of things if we went there.
And I think that's true both for textual and for purpose reasons, right? Textually, just as an example, Section 230 has exceptions for things like federal criminal law, for intellectual property, for privacy, exceptions that wouldn't really actually make any sense if the main protection were limited to defamation, because if it was only about protecting against defamation, there wouldn't be a question as to whether or not federal criminal liability was implicated or not. So I think that's at least one textual reason to think that publication is meant to be broader. And I think from a purpose standpoint, as we've talked about, Section 230 is about promoting the ability of users and others to speak on the internet. And if you were protected from liability for defamation, but not any other form of liability, then the same considerations around the heckler's veto and the incentives that providers would have to take down information would remain for the vast majority of content, except maybe that one corner of defamation. So I think both from looking at it from the policy that Section 230 was intended to enforce, and from the text, I think it's pretty clear that it's not really limited just to defamation.
Oh, there are a number of ways also that plaintiffs could creatively replead. They could claim intentional infliction of emotional distress, negligence claims, none of which actually require publication of anything.
Well, and Zarin was a negligence claim, in fact.
Exactly. And there's also, Google made the point that if C1 only applies to those kinds of claims, and C2A, which protects for voluntary takedown of content, if that really only applied to defamation and didn't really bar any distributor liability, there would be no conceptual reason why a platform would ever seek out and voluntarily take down information and give themselves the knowledge that would subject them to liability down the road.
One of the things I think that Samir touched on too is we have in Section 230, we actually have the legislative intent as codified in Sections A and B, right? We have the finding statements and the policy concerns. And so when we talk about textualism, right, and everybody today is a textualist, Justice Kagan once said, right, we actually have codified in the text of Section 230 the legislative intent. And that intent then can be picked apart by both sides who've tried to do that. Oh, it's about protecting children, right? That's why this is bad, what's going on. But the other side is obviously we want to promote a diverse marketplace of ideas and have less government, it specifically says, less government regulation in this space. So we think about, I think the big picture as we think about Section 230C1, we also have C2. We've got to read the entire text together. I think that's kind of the big picture. It's like C1 gets all the attention. That Shane said C2 is okay, we can remove it, but then we get the definitions of access software provider that comes up, and I think that's big in terms of organizing content. So really the text has legislative intent in it, and it has multiple parts, and I think the justices are probably going to go looking through both of those.
Yeah, and there did seem to be kind of an interesting textualist versus originalism debate going on in oral arguments. Justice Jackson, maybe surprisingly, going a little towards the originalism argument, talking about the purpose of 230 and its purpose for, as you said, cleaning up the internet. And her question was, shouldn't we read the statute in a way that makes it clear that platforms only get protection when they are actually doing those things to help clean up the internet. And she was drawing, I think, from the Cyber Civil Rights Initiative's brief, which argued that 230 should only give any protection when a company is actively, taking down harmful content. So, is that a rational reading? Should we adhere to the purpose of cleaning up the internet and that only?
I don't see how, I honestly don't see how we can adhere to that reading as appealing as it is to somebody like me personally. The entire, like, as Clay was just saying, you have to read the whole statute together. And so you have the part where you don't have liability for leaving things up because you take other things down, is my summary of Section 230. You don't have liability for the stuff that you miss because you do your due diligence and you really do try to clean up your service and offer a healthy and good environment for people to enjoy. And that goes back to the very first cases that motivated Section 230, which found that, they found that Prodigy had liability precisely because it was taking down content. And the court said, well, you're doing it over here, so you missed this defamation and you're liable for it. So Section 230 is actually about allowing a lot of these platforms to both to clean up their services and to make their services particular to their business purpose, right? To make them particular to travel, to make them particular. Everybody likes to say knitting. I'll go with knitting. And so I do not think that we can that is a workable solution as appealing as it is, precisely because platforms are always going to miss things, but that shouldn't mean that they cannot make their services useful, that they cannot continue to iterate upon and use their terms of service. So that's my view. I really wish there was a way to eradicate hate speech from the internet, but that is just not how I see Section 230 working, or how I see it working in the most beneficial way.
I think that came across in some of the amicus briefs. from those who would want to roll back Section 230 is the disincentivization argument, that if you create this big, block from Section 230, it disincentivizes actions taken to remove content. That's kind of how they frame that typically. I think if the court adopts that, it'd be rolling back lower court precedent all over the place. And I think that gets into what I'd like to think of the Roberts Court's penchant, in some cases at least, for minimalism, judicial minimalism, doing no more than is really necessary to answer this particular question, and we don't want to disrupt the status quo. So even in Dobbs versus Jackson Women's Health Organization, remember what Roberts did. He would have upheld the 15-week limit, but he wouldn't have rolled back Roe versus Wade. That's an example of judicial minimalism. I'm only going to address the one question here. I don't have to go any further than that. And so I think that there'll be a tension, as you're suggesting, I think maybe between Jackson's view there, we're going to look at the policy concerns about protecting children and incentivizing removal of content, versus we don't want to disrupt the entire status quo that exists. And Justice Kavanaugh talked about economic dislocation that would occur. That was his phrase, the massive amount of economic dislocation that would occur if we're to roll it back in any way. So it'd have a huge disruptive effect.
Yeah, I think there also is a plausible First Amendment problem with that if C2A allows platforms to take down content and be immunized for whether or not it's constitutionally protected. And if the protections of C1 are conditioned on them actively doing the thing under C2A, you get to the problem of, okay, does that create some kind of state action? Maybe not the strongest case, but plausible at the very least. So on the textualist side, as was mentioned earlier, there's the definition of access software provider, which is explicitly included in the definition section, is allowing or providing the immunity to software that picks, chooses, analyzes, digests, and whatnot. It strikes me, and I think a lot of the amici in the parties, or at least the respondents, that this is fundamental publisher activity with anything. And do any of you have thoughts on that in particular?
I think this gets to the heart of the real question that was raised, the central question that was raised, which was this alleged distinction between recommending content on the one hand versus displaying content on the other. And at least the petitioner's argument shifted over time, but in at least one iteration of their argument was essentially that publication was about the display of content, but when providers recommend content, they are no longer in the publication bucket, but instead are doing something different. They're contributing their own opinion and therefore don't fall within the scope of Section 230. But I think, our brief certainly argued, and I think a number of briefs argued, that that was a distinction without a difference, because when you're talking about most service providers on the internet, one of the things that they have to do inherently is there's such a huge volume of potential content that could be displayed. If you think of YouTube, there are millions of videos. And so almost by definition, the provider has to choose and select certain videos to display. Or if you think of a search engine, inherently what are the first page of search results? It's essentially the recommendation by the search engine as to what are the most likely responsive sites to the query that the user entered. And so recommendation is sort of inherent in the choices of what to display, how to rank them. And so that distinction that petitioners are trying to draw between publication activity on the one hand and recommendation really is a false distinction in my mind.
I think that comes through. One of the arguments that was made in some of the amicus briefs is that a newspaper recommends content to you by where it places it. Is it above the fold? Is it below the fold? Is it on page 1? Is it buried on page 10, right? And so those kind of suggestions or recommendations, and I would say that was something that the justices weren't even clear on. What do we call this? Thomas says, I don't think these are recommendations. I think these are more suggestions. And then Schnapper, who was arguing the case, said they're encouragements. So I think, what are we really dealing? It's like Seinfeld. What's up here? Is it an encouragement or recommendation? What is it? So the justices were so confused even about that. What's really going on? If I have, a thumbnail, here's the up next video, and again, I guess the big question, to go back to what you started earlier, whose content is it, right? What's the content in question, and whose content really is it?
I would also just add that one of the things that is sort of baffled me about a lot of the discussion that we're having surrounding Gonzalez, the Gonzalez case, is The material contribution test is right there, everyone. It is right there. So we're all like tying ourselves into knots over, is it a recommendation? What is a recommendation? What is publishing? When what I think we should really be asking is, what is the cause of action? And to what degree are we alleging that Google materially contributed to what is making it illegal? So when you look back at, for example, another old employer of mine, the ACLU's case against Facebook for some of its advertising practices. That had nothing to do with the content. It had to do with Facebook making decisions that were discriminatory regarding who got to see certain opportunities versus who didn't. And that was where we made the distinction for Section 230. This was not about content. When we look at Gonzalez, however, the cause of action is very different. And the problem here is that people saw terrorist content. And we really need to look at what the platform has done. What did the platform do that contributed to what was allegedly illegal that happened? And I think that will help us all clarify things and get us out of this, what's a publisher, what's a distributor, what's a this, what's a that. It doesn't 100% matter, because we should really be looking at each cause of action as it comes, as I'm pretty sure 230 intended to begin with.
Yeah, and just the sheer number of justices who said the words, "I don't understand what you're saying" at oral arguments was something to behold. The line drawing attempted at oral arguments was unsuccessful, let's just say.
If I can just add on that, I took down some of the quotes. This is Justice Thomas to Attorney Schnapper. Thomas said, well, it's responsive. He was talking to his answer. He goes, but I don't understand it. Jackson said to Schnapper, I guess I'm thoroughly confused. And then Alito says, I'm afraid I'm completely confused by whatever argument you're making at the present time. So we're back to that terrible Phil Collins Land of Confusion video, I think, from the 1980s.
You're full of references today.
Yeah, I am. I'm full of a lot of things, but that's okay. Thank you.
But I think Kate makes a good point that we really do need to consider the question of where the content came from. What is the thing that, where did the harm actually come from? And this was present, again, in a lot of the briefs, seem to completely miss the point and argue something that recommendations are equivalent to the message that you will like this, and therefore that is independently created content. But I was saying to Clay earlier, if I say you will like this, and that's nothing else, and he jumps off a cliff, he can't. His family can't sue me for saying the words "you will like this." If I said "you will like this" and it was a video on how to jump off a cliff and die, maybe they'd have a case, perhaps. So it seems to me that you cannot successfully extricate the message "you will like this" from the fact that the harm comes from the content that they will apparently, supposedly like. Is that how you see things? I think I know the answer to that.
Yeah, I think that's right. I mean, this was the line that the Solicitor General tried to draw, I think,
Right.
in their brief and in their argument. They tried to argue that there's a distinction between the recommendation itself versus the content that's being recommended. And they said, to the extent that the cause of action arises strictly from the recommendation, divorced entirely from the content, that could be that wouldn't be protected by Section 230. And according to the Solicitor General, that would arise very rarely, that it would be very rarely the case that you'd actually have a viable cause of action strictly from the recommendation itself. But I think what the justices recognized and pushed back on in the argument is that that would just open the door to exactly the kinds of litigation that we've been talking about from the beginning as sort of the real purpose behind Section 230. Because if states could start passing laws saying, recommending this harmful content is a tort or gives rise to civil liability, then you'd end up with these questions about, well, okay, is the cause of action arising just from the recommendation? When in fact, it was because the recommendation is tied to allegedly harmful content that would really be the underlying harm that we're talking about. And so I think this idea that you can separate the recommendation from the subject matter of the underlying content, again, really, at the end of the day, doesn't make sense. And if you were to try to draw that line, you would really undercut the purposes of Section 230.
I think that's right, and that kind of ties in with another idea, and that is, publishers in the offline world, generally speaking, don't have a duty to protect readers from the harms that come from reading bad ideas. Tons of cases about, one of my favorite is the person who bought a field guide to mushrooms, and one of the mushrooms that was identified was absolutely not safe to eat. And she got very sick, and the court, said there was no duty of care to violate, because if we held publishers to that, they would only publish the most anodyne, safe possible content. Same goes when parents of kids who imitated things on TV try to sue the networks. We don't want to impose that duty because of First Amendment concerns. So it's been suggested that if this case was different, if the facts were that a kid was presented a bunch of suicide or eating disorder content and was harmed by the repeated feeding of that person that content, that maybe that would be a better case. I think the First Amendment probably gets in the way of that liability too. And the response to that is, well, then why do we need Section 230? So should we still be worried about restricting Section 230 and narrowing it if the First Amendment's going to take care of most of these cases anyway? Kate, you alluded to this earlier.
Yes, absolutely. Yes, absolutely. Because again, the internet is more than Facebook, who can take or at least used to be able to take all of the lawsuits that could possibly be thrown at it. Google as well. If you exist in a structure where you are allowing, if you have a business where you are allowing literally anyone in the world to post whatever they want, and you are, doing your best to moderate, that'll never matter. That'll never stop illegal content or illegal activity from happening on your service. That will never stop, for example, CSAM from appearing on your service. And platforms have a duty to report CSAM. That'll never stop harassment from happening on your services. It will definitely never stop defamation happening on your services, especially if you're allowing things like ChatGPT to generate text and show up on your services. So you need Section 230 to prevent you from having to go to court constantly, rather than having to litigate to the finish to figure out whether the First Amendment protected the speech that you published or not. Because if that's your choice, you are going to either go out of business, as many websites did following the passage of FOSTA, or you are going to moderate a lot more. And the content that you are going to censor is going to be all of the content that is from marginalized communities, from the LGBTQ community, by content produced by Black and brown people. Any content that deviates from what the standard white cis heteronormative content looks like is probably the content that is going to get swept away in any new regime that has to appear after 230 disappears, because that is always what happens. We have seen it happen in the past. It will happen again. And so that is why we need 230. Like, if we really want to have a speech environment where everybody gets to talk and everybody has a chance, like think about Me Too, for example. This is a perfect example of what would not exist without Section 230. Me Too is a situation where women spoke up about sexual harassment and sexual assaults that happened to them. If it was false, if there was a chance it was false, that's defamation. That is defamation right there. If I am a platform, that all comes down if I don't have Section 230. Instead, the platforms were able to amplify, allow those messages to become a movement, essentially. And that, to me, is one of the best examples of why 230 is absolutely necessary. And the First Amendment just won't do it at this point.
To go back to Ari's point too, so again, we cut it off with Section 230. We never have to get to what basically is the incitement to violence standard that you were talking about in terms of the First Amendment protection. So the cases that you were referencing were really instruction cases. Here's the cookbook, how to do this, and something's poisonous, or the imitation of violence ones. And I think that's the relevant one. And you'd have to go down this incitement to violence test, which asks, is the speech directed to inciting or producing imminent lawless action, and is it likely to produce it under a case called Brandenburg versus Ohio? But again, Kate's point is we don't even need to go there with Section 230 because that can be a long battle. And even though inevitably in these cases, like if you applied that to YouTube, Google's videos that are posted, they have no intent, right? Because that test, that Brandenburg standard says, is the speech directed to inciting or producing imminent lawless action? And directed means intent. And they're going to say, no, we didn't post this with an intent to do it. But Section 230 allows you not even to have to get to that point. So.
Yeah, I think one thing it's important to note about what Kate said with the removal of anything that could theoretically be defamatory, platforms certainly are not investigative bodies, and they can't be expected to actually be able to tell whether anything is defamatory. And even if you have a notice regime that might supply knowledge, that just leads to people saying this is defamatory, and the platform says, okay, I can't really investigate this, so I'm just going to take it down and protect myself. So you end up with all that content coming down one way or the other. We have 5 minutes before Q&A, so I do want to ask one more question. The Supreme Court will, next year, maybe, hopefully, probably deciding the net choice cases about Florida and Texas's content moderation laws. How could the court's decision in Gonzalez affect either A, the justice's view of those cases, or B, potential outcomes depending on that ruling?
I mean, one thing to think about is that there's a potential tension between the way Gonzalez comes out and those net choice cases, in the sense that if the court in Gonzalez were to narrow Section 230 immunity and make platforms more potentially liable for third-party content, and then you turn around in net choice in the net choice cases where you've got states essentially trying to force platforms to leave content up or not take it down, then you could put platforms really between a rock and a hard place, where on the one hand, they're potentially liable for the content they leave up. On the other hand, they have obligations now under state laws to leave up content and have less freedom to moderate it. And that really could put platforms in a situation where they really don't know what to do, and they're forced essentially not to allow third-party content onto their services, or to really narrow what they're allowed, because otherwise they're between this rock and a hard place.
And Section 230 has that preemption provision about state laws that would be inconsistent with or conflict with Section 230. They're preempted. So in the net choice cases, then you're really tapping into the big First Amendment interests about editorial control and discretion, and the analogs to cases like Miami Herald versus Tornillo, where you cannot compel a print newspaper to publish content against its will. So you, in those cases, and I know that will be coming up later, you really have a First Amendment right not to speak, as well as a First Amendment right to engage in editorial control and discretion, regardless of whether it's fair or unfair, the court said in Tornillo. So you're really getting into the First Amendment issues there.
I think we are going to go to Q&A now. I have some questions from the online viewers. The first is, would you provide thoughts on the politicization of criticism of Section 230 with the role of big tech? That's a monster question.
Yeah, I mean, look, I mean, we've been talking about the courts, but obviously another arena where this is all playing out is in Congress, and where, not surprisingly, the politics are very much at play. And what's interesting in Congress is that on the one hand, you certainly have a bipartisan push to reform Section 230 of complaints from all sides that Section 230 should be reformed. But when you look at what it is that they want to accomplish through reforms, Democrats and Republicans have very different goals, because the Republicans, by and large, complained that platforms are engaged in bias against conservatives or conservative viewpoints. And so they want to restrict the ability of platforms to moderate. They want to force them, like the Texas law would do, to be quote unquote viewpoint neutral. And so they're trying to have platforms do less in the way of moderation through reforming Section 230. Most Democrats, on the other hand, think that platforms aren't doing enough with respect to hate speech and other kinds of harmful speech. And they want, therefore, for platforms to be doing more, to be incentivized to do more. And their view is that immunity creates a disincentive for the platforms to do more. And so they're really trying to accomplish very different objectives for political reasons, which is why I think Section 230 reform hasn't actually made its way through Congress in any meaningful way, because even though everyone wants it, they want to accomplish very different things. Conceivably, if the Supreme Court rules in a way that really breaks the internet in terms of how it deals with Section 230, Congress won't have a choice but to deal with Section 230 in some way. But absent that, I think the politics of it actually make it quite difficult.
I knew it was you. The only thing I would add to that is one of the things that's really missing, I think, from the debate in Congress and definitely at the state level as well, is the idea, which we have brought up a number of times in this panel, and I'm going to do it again, that the internet is not Facebook, Twitter, Google, YouTube, and Amazon. It is just not. There are so many other services that exist and that need this protection far, far more. And when we zero in on those companies and the problems that we see with them, we are missing the forest for the biggest 5 trees. And that has been, I think, a real challenge. One of the places where we've actually seen a breakthrough in that, where we've seen some attention given to sort of the rest of the internet, is in the EU. And that's an eye that policymakers should have an eye on how that law is about to be implemented. There will be flaws, absolutely, but there could be guidance for us as we are continuing to look at this from a policy perspective.
Okay.
I was just going to quickly emphasize Kate's point. I mean, in that sense, Section 230 is actually a pro-competition statute, right? Because, as Google's counsel said at the end of the Supreme Court argument, she basically said, look, if you reform narrow Section 230, we as Google will survive. We'll find a way. It's the smaller providers who basically won't be able to handle that flood of lawsuits or to have the resources to deal with that potential liability. And so you'll end up concentrating the market even more if you impose liability.
I would just add, when we're thinking about Congress's role here, we're really talking also about something that percolated up through some of the justices' views is really separation of powers. Who is this to decide? And I think Justice Kagan drew laughter when she said, and her quote was, we're a court. We really don't know about these things. These are not like the 9 greatest experts on the internet. And so, and Justice Kavanaugh tapped into that as well. In other words, the court's not going to rewrite this. It's really for Congress to go back and do it. But the problem, as we're suggesting, is Congress is kind of deadlocked and they're attacking it for different reasons. So, but I think that goes to the minimalism part, that the court will say, we're not going to rewrite this. It's separation of powers. This is for Congress to do, but then they throw it back to Congress, and Congress probably won't get it done.
The second question is, Kate mentioned hate speech, but what does Section 230 do to actually define hate speech, and how does it impact freedom of speech without overstepping its boundaries before bringing the publisher versus distribution question? And I'm not sure I get the second part of that question, but there it is.
That's you.
It comes back to me. Nothing. Section 230 doesn't say anything about hate speech. And more than that, the First Amendment protects hate speech for better or worse, sometimes for better, sometimes for worse. My definition of hate speech is probably very different from yours. Whoever asked that question, everybody in this room, we all have different definitions and conceptions of what it is, and that is part of why it is essentially protected speech. What is not protected is, harassment, true threats, incitements to violence. What was the second part of that?
How does it impact freedom of speech without overstepping its boundaries before bringing the publisher versus distribution question?
Okay. So Section 230 comes in, I'm going to take this as a process question. Section 230 comes in long before you even have to reach the idea of whether the speech at issue is protected by the First Amendment or not, whether it is and that is the whole point. It is supposed to provide speech platforms that are going to be the speech for hundreds of thousands, billions of people, the ability to provide that platform in a sort of frictionless way, such that you can post pretty much immediately to any of these platforms, regardless of what it is that you are going to say, as hateful as it might be, as disgusting as it might be, as defamatory as it might be. And the platforms can allow it to happen, can allow that to happen frictionlessly, but then come in afterwards and moderate it if it violates their rules. Not if it violates some government rule, but if it violates their rule about what the platform is about, or what the platform says it wants its environment to be. So, Facebook, Google, they all have rules against hate speech. They all have rules that they try to enforce as best they can against these types of content, sometimes more successfully than others. I think that there are strong criticisms and valid criticisms to be made about how platforms enforce their rules, but those aren't government rules. And a lot of the speech that platforms take down is in fact First Amendment protected, but it is the platform's right as a First Amendment protected entity itself to decide what content it hosts and what content it doesn't, because what it's trying to do is create a platform that people want to be on. And people don't want to be on a platform that is a cesspool of racism, hate speech, and violent content, mostly. So that's my answer. I hope it helps. But yeah.
I would just add one point. Kate's very rightly made the point about diversity of the internet, and that you shouldn't be talking about the 5 platforms. But it's also true that content moderation is diverse too. And another aspect of content moderation to remember is that a lot of services, if you think of Reddit or Discord, have community-based moderation, right? Where you can, where they allow moderators to form their own communities and decide this is the kind of speech we want to allow, this is the kind of speech we don't. And so allowing that freedom in terms of what's hate speech, what's not, allows for the development of diverse kinds of communities and allows users to choose, this is the kind of community that I want to participate in or I want to speak in.
And I think Kate's point is important there too. There really is the First Amendment right that gives the ability of the platforms to take down content that otherwise is illegal. Section 230 has the provision in it where it says that otherwise objectionable, whether it's legal or not, and that's where hate speech would fall in as an easy way to cut it off.
And I would also just throw in context matters in every single circumstance, but especially when it comes to hate speech. So, for example, there are words that I, as a white woman, as a white person, if I used them, they would be per se probably, in the opinion of many people, hateful. But if someone else with a different color skin used them, it might be seen as a term of endearment or affection. These are things that are very, very difficult to parse for platforms that are trying to engage in content moderation. And so I think that's part of why Section 230 doesn't say anything about hate speech, and part of why the First Amendment protects it, because context is so specific and so granular in that way.
We have a question in the audience.
J.P. Hogan. I wrote full-time in 2008 and 2016 to defeat Hillary, but on this comes out of 1996. And did the Clintons leave it this way so that because as means motive opportunity? When Hillary ran, the tech companies were mostly trying to help Hillary put Bill Clinton back in the White House, even though he's a term-limited president. So where are the public morals in originalism? If we're under originalism, separation of church and state, whether it's vertical or a wall of separation, the government also under God, is there the public morals that there's no right to bear false witness, you shouldn't be coveting? So in the content, in the balancing of content, are you already under the public morals of that you shouldn't be bearing false witness?
I mean, I would say, look, we have a First Amendment in this country, right, which says that recognizes that different people have different morals and view, different kinds of speech as moral or not, and gives people the freedom to speak with very limited exceptions based on their own view of morality. And I think Section 230, in similar ways, for the reasons that we've talked about, advances a similar vision as to the freedom of individuals to speak in ways that are consistent with their own morality.
Maybe one of the big picture things we haven't talked about yet is that the Supreme Court in the Reno versus ACLU case said that speech and internet speakers deserve the most protection. The First Amendment, just like they would be, is a foundational point, just like a print medium. And I think that's important too in terms of the choices that we're dealing with.
We have one more question from the online crowd. Would you address the role of algorithms, particularly when considering the incorporation of AI and machine learning based on user patterns, in which the tech provider uses to guide or suggest other options? I mean, that is what the entire case is about. So I'm not really sure what more there is to say about it, but if you have thoughts.
I would just say that algorithms do a lot of different things. So this case involves a recommendation algorithm that is basically like, that is sort of the basics of it are, you seem to like this content, and so we show you more of it. And that's what the algorithm does. But algorithms do a lot of other things in this world. They recommend many other types of things. At Wikimedia, we had an algorithm that recommended to people articles that they might want to add citations to. They're like so the idea that like algorithms are somehow magical, or that there's one kind of version of it of what this thing is just isn't true. And there are also things about it that we need to be very careful about. In the recommendation context, Gonzalez versus Google, we've been talking about it all day long. But there are ways that companies can use automated technology that can be illegal, that can engage in discriminatory behavior, that can exclude people from seeing housing advertisements, that can exclude people from credit opportunities. And these are all things that we really need to pay attention to. And with algorithms, specifically with AI, it's garbage in, garbage out. If your training material, if your data is terrible, if it is based on biases because it's written by humans, those are all things that we need to be aware of and that we need to be testing and that we need to be clear about. Otherwise, we are just supercharging an existing problematic system to just do more of what has always been done more quickly and with less accountability. So that's what I think about algorithms. Like, does 230 step in to protect companies from the decisions their algorithms make? I think so sometimes when it's just republishing content or recommending content, and the cause of action is based on the content itself. But there are other circumstances in which that will not be true. And 230 will not be a bar to liability and should not be.
Algorithms also are responsible for presenting content chronologically, so it's kind of hard to tease that out. We have one more question.
Thanks, Ari. Steve Del Bianco with NetChoice. Great panel, and I would appreciate the flip side answer to Ari's question on the interspace between the NetChoice cases and Gonzalez. Let's suppose that the court rules correctly for Google and that algorithms are protected by 230. My question is, does that free up the court then in the NetChoice cases to say, given that you're protected broadly with the feeds, we'll agree with Justice Thomas, Alito, and Gorsuch, and make you carry everything, which is exactly what the Texas and Florida laws would have done. In other words, it's the opposite of what you were worried about, Samir. If they hold for Google against Gonzalez, does the court suddenly find 5 votes to allow Texas and Florida law? Thank you.
I'm not going to predict what the court would do, but I would say they shouldn't, both for the First Amendment reasons that Clay alluded to earlier, in terms of the, I think we have a strong tradition, First Amendment tradition in this country, that newspapers and other carriers of content have the First Amendment right to decide what content they carry, how to carry that. But I think also from a policy standpoint, again, we want to allow providers and communities to set up different kinds of platforms, some of which may be free speech and anything goes, some of which maybe we want to allow content only about a particular subject matter. We want to allow, we want to remove harmful content. So, Texas talks about viewpoint neutrality, which sounds good in the abstract, but when you think about it, there's content relating to self-harm, and maybe we want platforms to take down content that promotes self-harm, but leave up content that provides resources so people who might be thinking about self-harm know where to go to get help. Or when you think about terrorism, which is the subject of the Gonzalez case, maybe we want some platforms to make some efforts to take down ISIS propaganda, but nevertheless to leave up content that tries to talk about the flaws in ISIS thinking, or that tries to de-radicalize people. And so if we want a diversity of content and views on the internet, that requires leaving platforms the ability to make their own choices. Because otherwise, if everyone has to carry everything, we end up in an internet that A, is going to be unusable for a lot of people, because it's just going to have spam and all sorts of content that no one wants to see. And two, we sort of lose the idea of having diverse communities that allow people to make choices about who they want to associate with, who they want to talk to.
All I would add to that is an example, because I don't know what the principal distinction is that Texas or Florida has made between the top 6 platforms and everybody else. So let's engage in the thought experiment of Texas's law applying to Wikipedia. Can anybody do it? No, you can't, because it doesn't make sense. Wikipedia is an encyclopedia that is created by its users in a collective way. And it cannot be that the users themselves cannot engage in applying the rules that they have by consensus created to remove content that they think does not belong on Wikipedia. And that example to me, possibly because I used to work there, but it really crystallizes what I think is deeply missing from a lot of the policy debate that is going on right now, which is focused entirely on the big platforms and the large social media environments, and missing all of the things that these laws and these proposals would apply to if we are not careful. And I do not know the difference between the definition of the platforms to which Texas's law applies and sort of everybody else. Wikipedia, for example, has enough users to potentially be encompassed by that definition. I'm not sure that it is. I don't think that I would argue that it is. But I don't. That is the thing that I really don't understand. So legal policy, yes, but also just practically, what are we talking about if we are going to force all platforms to host certain speech regardless? Assuming Travelocity gets gigantically large in the next couple years for whatever reason, do we need to see Ron DeSantis's speech on comments on Travelocity? Because that's exactly what Texas would sort of have us experience, and that doesn't make a ton of sense to me.
Quick last word from Clay.
Very quickly on that, the two decisions are very different in terms. The 11th Circuit is much more of a very traditional First Amendment analysis. The Fifth Circuit is frightening. It is a text, history, tradition analysis that plays totally to Justice Thomas and his interest. It takes the Bruin case, which was the New York State Pistol Association and the guns law. It imports basically into First Amendment free speech jurisprudence this text, history, tradition approach that turns First Amendment law really upside down. But because those two cases approach it from different avenues, the Fifth Circuit's decision, the Texas one, really unfortunately allows a Thomas Alito kind of viewpoint to come through. And so they're going to be huge when they come up.
Thank you to all 3 of you for sharing your thoughts with us, and we are out of time.
Thank you for joining our panel on the economic considerations of Section 230 reforms. I'm Mark Jameson, a non-resident senior fellow at AEI and a Gerald Gunter professor at the Public Utility Research Center at the University of Florida. So we've got an abundance of Floridians here for whatever reason that might be. We're here to discuss the economic impacts of Section 230 and what might be the economic fallout of any reforms. I'm joined by three well-known economists or people working in this space to discuss these issues. Joining me are Doug Holtz-Eakin. He's president of the American Action Forum. Sarah O. Lamb, a senior fellow with the Technology Policy Institute, and Kate Tumorello. She's the executive director of Engine. I'll briefly introduce each, and our panel will run from now until about 11 o'clock, and then we'll have about 10 minutes for Q&A with the audience. Prior to joining forming the American Action Forum, Doug was in academia for about 20 years and also served in a variety of policy positions, including chief economist of the President's Council of Economic Advisors, Director of the Nonpartisan Congressional Budget Office, Director of Domestic and Economic Policy for the John McCain Presidential Campaign, and a Commissioner on the Financial Crisis Inquiry Commission. Sarah brings us with some unique perspectives for this panel. She's an attorney and an engineer and an economist, so internally she's conflicted, I think. But she'll be very clear in all of her thoughts and that she shares. Before joining TPI, she was the Operations and Research Director for the Information Economic Project at George Mason School of Law. And she's presented her economic analyses at numerous research conferences. And though if you look at her bio, she doesn't say so, she was really very helpful in writing Florida's strategic plan for broadband. I'm grateful to her for that work. And as director of Engine, Kate works on privacy, intermediary liability, and telecommunications issues. Previously, she worked on surveillance reform issues at the Electronic Frontier Foundation, and she's also served as a technology policy reporter in Washington, D.C., including at Politico, The Hill, and Communications Daily. So Doug, Sarah, and Kate, welcome. So let's jump into this. Doug, let's begin with you. You've quantified some of what you see as the economic impacts of Section 230. So please tell us what you found and why that matters.
Well, first, let me say some thanks. Thanks to Mark for inviting me, AEI for having this event, my co-panelists for tolerating me, but mostly Jeff Westling, who has taught me everything I know about the law surrounding Section 230. And today we get to talk about the economics, which I'm trying to teach him. So, like everyone who's on this panel, the price of getting in was to file an amicus brief with the court on Gonzalez versus Google. So coming out of that are some of the things we sort of quantified as the dangers of overturning Section 230. It has enabled an enormous amount of very dynamic, competitive economic growth, and at this point, the internet economy is roughly $2.5 trillion, something that is about 10% of U.S. GDP. It employs something like 17 million people, depending on where you draw the boundaries. And it's growing much more rapidly than the rest of the economy. If you look at the most recent numbers we could dig up, the years from 2016 to 2020, it grew by 22%, where the economy itself was grinding along at 2, maybe 3% each year. So there is no question that touching Section 230 is going to have dramatic economic ramifications, and my biggest fear is that most of them will not be well understood, that touching it will have a lot of unintended consequences that no one really thought about, and we'll be dealing with the fallout from that for the years to follow.
All right, thank you. So Sarah, let's turn to you. You've also estimated some of the economic impacts of Section 230, and you've examined how the instruments that underlie content moderation are actually pervasive across the internet, a lot of other contexts. So explain to us what you have found, please.
Thanks, Dr. J. Yes, and at TPI, we also filed an amicus brief, so that's kind of the panel here. And in our brief, we looked at the importance importance of targeting on the internet economy. We mentioned a statistic that advertising is a $200 billion per year industry online in the US, and it's growing year over year. Targeting and recommendations are central to pretty much everything you look at on the internet. Otherwise, you imagine a world of untargeted information, and it's pretty much that would be a random hodgepodge of information. So everything you see is curated and ordered and prioritized. In our brief, we look at just what that means in terms of the scope of what a decision by the Supreme Court could possibly touch, and it would be, the whole economy. And we look at the digital economy, stuff that's online, but also offline. So you look at the internet to go purchase stuff in the real world, in retail stores. And so we kind of emphasize that point. But we also go down that road of, well, what is a recommendation? Since the petitioners brought up the point, recommendations are somehow different or need extra scrutiny, well, we kind of unpack that for the Supreme Court and we say, well, here's the economic literature on targeting and how to measure outcomes. The economic literature is pretty varied. When you see bias in advertising or in job listings, it's the algorithms, it's a statistical exercise. It's not necessarily a human being saying, oh, we want to bias one type of information over another. So we go through those scenarios for the Supreme Court. If you're going to go down this road of drawing lines around recommendations, this is what it would look like, the analysis.
Okay, thank you. And Kate, my apologies. I think I threw you in as an economist a little bit. I hope you're not offended.
No, not at all.
All right, very good. Well, we've discussed a lot of economic impacts and the pervasiveness of all the business practices that Section 230 enables. So let's drill down, because your organization represents people who have virtual boots on the virtual ground in this space, if you will. If I were a small business where content moderation, information algorithms all mattered to me, what should I be worried about here?
Yeah. So thank you for having me. And yes, I am not an economist nor a lawyer. I am a lowly startup advocate. And so we kind of come at this from a very different perspective. And I think that the previous panel touched on this well, but we are armed with data here on this. So one of the things we always like to say is that the average seed stage startup, so that's about a 2-year-old startup who's seen some success and is starting to seek outside funding, so a somewhat successful but still small company, has about $55,000 a month to spend on everything. That's payroll, that's rent, that's equipment, that's marketing, you name it, it has to fall in that $55,000. A single lawsuit with Section 230 in place over user content can cost tens of thousands of dollars to get dismissed. So even in the world we're already living in without changing any laws, a startup that hosts user content could have at least a month of its funding wiped away by one lawsuit. If 230 were to change and a startup were to have to go through a full trial, even if they win that trial, that could cost hundreds of thousands of dollars. So that's many multipliers of $55,000. And so we kind of really are focused on how do we make sure that the policy conversations around Section 230, to the point in the previous panel, aren't just focused on the handful of companies who can easily afford lawsuits, but take into account the fact that there are all kinds of internet companies of all sizes hosting all kinds of content, photos, videos, reviews, messages, you name it, and specifically for all kinds of user communities. And those are the folks that need 230. Of course, Google will argue they need 232, which is fine, but we really see this as like a crucial law that helps ensure that a platform has an incentive to exist, and equally importantly, that investors have an incentive to invest. We know investors cite intermediary liability frameworks as one of the reasons they feel comfortable investing in internet startups. No investor wants to write a huge check and have most of it go to lawyers, and so this law is so important to the part of the startup ecosystem that needs the ability to host, moderate, recommend, et cetera, user content.
Let me ask you, Kate, to expand on that a little bit. Because as I look at a lot of laws that go before Congress here in DC or go across state legislatures, at least get proposed, they try to distinguish between the big guys and the smaller guys and say, oh, we just mean that we'll put rules on the big guys. How does that really play out in practice? Is that a good idea? Does that kind of protect a lot of people in your organization? What are your thoughts?
So the states certainly have tried to write rules, I think from a philosophical point of view, Engine isn't a huge fan of startup carve-outs because every startup wants to be a big company, especially if you're a platform that hosts user content. Like, you have value in the network effect. You want to scale. You want to have as many people as possible, and we tend to think that small business carve-outs make sense if it's an administrative carve-out, right? And we talk about this in the privacy context a lot. Is there a way to say, for instance, in the privacy bill that was moving through Congress last year, if you're under a certain size, when you get a request to correct user data, you can just delete it. That's an administrative tweak around the edges. It doesn't actually change what the company has to do for their business. Changing 230 for companies over a certain size fundamentally rewrites what that company does. You would have to change your entire business model, your entire setup to be able to comply or shoulder that kind of liability. So I think in this context, those thresholds don't make a ton of sense, even though I can appreciate the thought behind them. I don't think it's not the silver bullet that I think some people think it is.
All right, and if anyone else wants to chime in on any of the questions I ask.
I
yeah,
just
go
want to
ahead,
echo
Doug.
that. I mean, this has been a longstanding pet peeve of mine, this sort of fascination with the special treatment of small firms under 50 employees. We do this a lot, but what we really are doing in the process is putting a tax on success, because we're going to get rid of whatever the special provisions are if you're at all successful, and that just doesn't make any sense. And so I'm really worried about it in this context. The Section 230 framework is enormously appealing for two reasons to me. Number one, the focus is directly on the consumer. You moderate content to attract people to your platform, and the market rewards success in content moderation for that reason. That's everything about market competition, and this enables it. So it enables it tremendously, and it allows entry of competitors in a very successful fashion, which is the heart of what Kate's talking about. And to damage that entry is to damage the ability to have effective competition. So I worry about them touching that a lot.
All right, so Doug, I'm going to ask you the next question that I have also. As you look around the world, a lot of the other countries don't have Section 230. They've got lots of social media platforms and other platforms, or do they? What are the lessons as you compare the U.S. to other jurisdictions?
Well, I mean, everybody has lots, but we have the most successful. And I think though they started out as small companies doing things in a particular way, and they have become global forces on internet commerce because of the ability to adopt a strategy of their choice that is delivered by the Section 230 protections. I think that's the real lesson, and they have been so successful, they spilled over into all other areas of policy. We now have enormous international tax consequences because our tech firms are large and successful. And you know, I don't think we want to change that. We want the next ones to be just as successful. I have no reason to believe that the particular giants of today will survive for any length of time. Competition is like that. We see giants disappear all the time in other parts of the economy, and the same will be true here if we keep the framework as it is at the moment.
Kate, you have something to add?
Yeah, this is one of my favorite topics to delve into. I think, the U.S. has kind of the richest and most broadly accessible startup ecosystem, innovation ecosystem in the world. Could we be improving it? Are there things we should be doing to make it better and more accessible? Absolutely. But globally, no one else holds a candle to us. So that's worth acknowledging and being proud of. I also think when people want to say things like, well, internet platforms have figured out how to comply with hate speech laws in Germany, so why can't we do that here outside of the First Amendment analysis, which is incredibly important? I would ask, have they? Is anyone besides the very large companies able to comply with the hate speech laws in Germany? If you have to hire a lot of content moderators who are in the country, who know the culture, who know the language, who can kind of interact day to day with this stuff, that's not something anyone else besides the large companies can afford to do. And you have to take into account the legal environment, especially in Europe, is very different. For better or worse, and although I would argue for worse, we have a court system that is set up to encourage if not litigation, threats of litigation. And especially around things like speech. The earlier panel discussed how difficult it would be for any one platform to be the arbiter of what is defamation in every case. It's very commonplace to see people use any tool they have at their disposal to try to suppress unflattering speech. And we see that with the DMCA in the copyright context a lot, where Me Too came up before. This week, in the news, there is an instance of a very well-known and successful actor and director using a DMCA takedown to get removed from Twitter a video of himself talking about sexual assault, which, if anybody looks at the facts of that case, of course that shouldn't be removed, but Twitter took it down because that's what you do with the DMCA. And so if we were to extend that and say, not only do you have to be worried about getting sued for copyright infringement if you don't follow the DMCA steps, you have to be worried about being sued for defamation in this country, it would look very different than what other countries look like, because in Europe you have loser pays, right? You don't bring or even threaten lawsuits that you're not going to win. We don't have that here, and it's very easy to make threats, even if they're not, even if they wouldn't win, and nobody even really thinks they would win.
So some of the research that I've seen on, and we're getting a little bit broader than Section 230, we'll pull it back in a moment, on regulation US versus Europe for the tech platforms, is that some of the laws that once they passed in Europe, suddenly all the entrepreneurship stopped. And the data is pretty stark on that. But I've also heard, and this was from some policymakers in Europe, that when somebody in Europe says, I want to be a tech startup, they move to the US. Does it show up in the engine membership that you're getting a lot of people showing up here that are from someplace else because it's just better here?
Yeah, I mean, I can't let that go without mentioning that the immigration system in this country is horribly flawed, and we deal with a lot of founders who want to be based here and want to hire here but have trouble accessing the immigration system. But yes, we see lots of founders move here. I think it's always tough to know, like, how much of the decline in innovation in Europe is due to GDPR versus other factors. And I think the same thing will be true of the DSA when we can see what happens there. But certainly, yes, this is the country to launch your startup in.
Okay, so let me expand on that just a little bit, Sarah, and ask you. You mentioned this is kind of a whole economy effect. So tell us more about kind of once you start changing what the rules are for the platforms, so you discourage the platforms, you raise their costs, what other sectors get affected? And in what ways do they get affected? So that when we look at a small business or a large business someplace else, we know what the implications are for them.
Yeah, so for a change on Section 230, I think the prior panel and our panel is talking, the internet is diverse. There's advertising businesses, there's encyclopedias, there's travel sites. It would be kind of a line drawing exercise to carve out, even between small firms and big firms. I just had the question as well, and I don't know if in Europe they have that, but how do you measure small and big? Is it by revenues? Is it by impressions? Like Wikimedia is huge, but it doesn't make a lot of money. Yeah. So do you count that as the number of visitors that go to a website and then you put the line there? Is that considered big? Well, for the purposes of influence, perhaps it's big, but then for purposes of revenue, and then small companies could be small in terms of viewers, but large in terms of revenues, like per user, they could be making much more money than other websites. So I think the line drawing exercise, it's almost like, oh, we have to regulate every sector, advertisers, recommendation, and YouTubes, and also travel sites and Nextdoor, so I think. And you see that in other regulations like the Digital Markets Act in Europe, or privacy, or how can you, and then even in the U.S. the proposed legislation, how do you really draw the lines and without adverse effects, and then you're going to have adverse selection, startups wanting to build in certain segments of the economy more than others, and then you lose that experimentation that has enabled so much innovation.
Right. Doug, did you have something to add?
I just think it's important to just think about it. I mean, content moderation is all over the internet in different ways, and it's intermixed with commerce in a million different ways out there. And if you start touching the content moderation, you're going to deeply affect the commerce. And so there's no part of the economy that's not going to be touched by this. And I'm really concerned about these sort of pretenses where we can target it somehow effectively and carve out, have no impact on the economy and just deal with this isolated content issue. I don't think that's possible.
Okay, so Sarah, another question for you. In your analysis, Doug's analysis, and in Kate's as well, they would, in economics jargon, they're dealing with the supply side, the costs of providing a platform. Some of the content providers complain about there's a demand side here as well. You know, if we can't tell how content moderation is supposed to work, that really affects our businesses, which is selling content on these platforms. What are your thoughts on that? Is there anything in Section 230 or reforms to Section 230 that would benefit the demand side, or is this about the best we could do?
Well, whatever the regulation is, that's what you'll get more of. So if there's stronger expectations of liability on websites for a certain amount of content, you're going to get more or less of that. So it gets to the point. There's a narrow line between regulation, and so there have been some proposals. Oh, there needs to be a regulatory agency to handle this kind of line drawing, but that there are a lot of reasons why that's not good for the economy, and an adjudicatory system is much better. It's case by case, and so I think when you're dealing with demand and supply, it's so dynamic, and how is Congress supposed to know? How is a regulator supposed to know in a centralized economy? You can't predict, and especially I think last panel we talked about algorithms and ChatGPT, and so you're only going to see more digital material online and more algorithmic content. It's going to get more complicated, and so I think it just makes sense by transaction costs that a case-by-case approach would be better.
Okay. So Kate, if I were asking a question like that to an undergraduate economics major at UF, they would say, well, there's a marketplace for that. Well, at least that should be their answer. Otherwise, you get a C-. And you've got a lot of people in your organization that are looking for opportunities. As Jeff Bezos said, your margins are my opportunity. Somebody else's mistakes in content moderation or somebody else's opportunities. How do you see that playing out amongst the businesses and the markets?
Yeah, I mean, I think social media is like a really interesting example, and it makes sense why so much of the 230 conversation focuses there, because obviously there are a number of platforms that kind of we all use. But I think, for instance, like DC dramatically overvalues the role of Twitter in public discourse. Certain pockets of people, right, use Twitter, and we are one of those pockets. But like, I promise you, my mom has never logged on to Twitter and never will. My mom is like of the Facebook generation, where every picture of any member of our family ends up on Facebook. So it can feel like, especially if you're a member of Congress who falls into both of those demographics, that those are the two social media platforms. But we deal with startups in the social media space all the time. Are they going to be the next Facebook? No, they'll probably be something better, honestly. Or there'll be something different. There'll be something that we haven't thought of yet. And even, like, I don't use Be Real. I think I'm too old to use Be Real at this point, but that's something that didn't exist 2 years ago that took off. So I think we need a hefty dose of like regulatory humility when we think about getting angry at 3 social media companies and rewriting the whole law, because we know there's a whole ecosystem of companies in social media, but also in other forms of user-generated content, and that's who we need to be thinking about protecting.
Right? Go ahead.
This
Doug.
is just this is another example of the issue, which is that regulators should be concerned about the consumer welfare in everything they do, but that's a really hard exercise. Mm-hmm. And staying out of it, letting the consumer compete with different platforms to figure out what they can get what they want is just much more effective, and we should rely on that mechanism more than any others.
Right, so Doug, another question for you then, just spinning this out a little bit more. Some people have been warning that pension funds, other investment programs should be worried about what the Supreme Court might decide here. What are your thoughts on that?
Well, I mean, the Supreme Court could destroy a lot of asset values if they broadly intervened in Section 230. There's no question about it. And those pension funds are holding those assets. They're going to fund the retirements of municipal workers and firemen and all sorts of people in the economy. So There is no, it's another example. You cannot insulate what is advertised as a content/algorithm decision from the larger economy. And even a targeted, narrow decision of some type is going to have repercussions. A broad decision would be devastating.
All right, very good. So we've got about 2 minutes before we start taking questions from the audience. So I want to ask Sarah one more question for you. The previous panel talked a little bit about legislation, Texas and Florida. So if you think about supply and demand for legislation, there's certainly a demand for some sort of reforms in how legal reforms and how content moderation is done. And the states, anyway, are interested in supplying that. What's going on there? What's motivating that? How should it be talked about?
Right. So I think everyone's watching the patchwork that's happening across the states. Even Montana, Utah, they have new laws out. And then there's the biometric realm, privacy. And so each of the states, they want a piece of regulating the internet. And so you're going to see more demand for Congress to say something, to have some general privacy rule or to weigh in on content moderation. But I think it'll be interesting to see how much of a patchwork will form. And because the internet is such a large part of our economy now, I mean, everything has a digital component. Brick and mortar shops have digital doorways or portals, and so everything does touch the internet.
Can I?
Yes.
I think on so I guess the demand side of that question, like politicians at the state level and at the federal level, or policymakers have realized this is a winning talking point. Hating on tech is a winning talking point. And I think that's some of it on the industry's fault for not like doing a good enough job describing why the companies we work with have value, which I think is pretty intuitive if you're willing to look past the talking points. But I think it really gets at how difficult content moderation is, because every single voter, every single person in this room probably has a story to tell about seeing something on the internet that they shouldn't have been there, or seeing something get taken down that shouldn't have been taken down. And whenever people point to that as like, yes, so clearly there's a problem, we need to amend 230, I say like, try being a content moderator for like 10 minutes. And you will see that like, I wish we could all just like nerd harder and get to a world where everybody could agree on what content should be on the internet and what shouldn't, and we could perfectly enforce that. But that is just not this world that we live in and will anytime soon, no matter the advances in AI and the tens of thousands of content moderators that companies throw at the problem. And so like this seething and frustration that we see that kind of bubbles up to state legislatures is real, but it's not something that we can solve, I think, with legal changes.
All right, very good. Doug.
So these state level initiatives are a big deal in this context, but I just want to note that this is happening in all areas of policymaking, and that you might like to think that state legislatures, the legislators themselves just woke up one morning and had an interest in these problems and decided they knew better about content moderation, and off they went. But the truth is, firms are going to the states where the costs of lobbying, the costs of getting action are much lower than at the federal level, and they're using them for competitive advantage, and it's not a good dynamic. It's something that's really worth watching across the agendas.
All right, very good. So if you're in the audience, have a question you'd like for the panelists, we have some microphones around. I have one on the internet right now. Let me get to it first. Well, let's go back here first, and then I'll go to the one on the internet. Yes.
Following the money, and when did they know, what did they know? With content, where does it cross a line to maybe premeditated campaign contribution? And you're like an in-kind, so if you're following the money, and where are these companies risking being of in excess of a campaign contribution with intentional intent? So where is the economy on warning people not to cross that line?
Okay. So perhaps, Kate, do you have an answer for that?
I think,
Go ahead.
I mean, I think, right, this question is kind of getting at are companies acting in ways to benefit one candidate over another, and recognizing that we have campaign contribution disclosure requirements. Does this fall outside of that? I've never worked at any social media company, so I can't speak from personal experience, but I do think this kind of also gets at my point that it can feel speech is so personal, right? And so and if you see your speech taken down, or speech you agree with taken down, or speech of somebody you agree with taken down, it can feel like that's mine. Why are you doing that? But I guarantee you, there is a one-for-one example of speech that you disagree with being taken down that you just never saw. Right? Like it's so hard to wrap all of us, our minds around all of the content moderation decisions that happen on any given day. And so when these anecdotes bubble up and feel very political, and of course our members of Congress politicize them, it skews the conversation. And I think I don't know that it does any service to like the broader 230 conversation. It certainly gets a lot of people worked up, which I think might be some of the lawmakers' intent. So to answer your question, I think that it can feel one-sided, and I understand why that feels like a campaign disclosure workaround. But it's probably less one-sided than it looks based on kind of DC conversation about it.
And the best insulation for those kinds of frustrations is to have another place where you can post that content. And so the preserving the robustness of the competitive environment and the entry of new platforms is the key to succeeding in the long run. Having some omnipotent regulator try to do it is a route to failure.
All right, let me go to one of the first question on the internet, then we'll go to back here. Okay, first question. From a business perspective, what degree, if any, has Section 230 impacted business insurance coverage? Any thoughts on Section 230 reform and its potential impact on that market? Yes.
Yeah, if 230 were to change, insurance costs would skyrocket. Right, we see this in the privacy space already. And I think so much of that comes down to the fact that like what happens in litigation is such an expensive but ultimately unknown thing. No company can ever say, I'll only have to spend this much on defamation lawsuits, because every day 100 new people log on to their website and could be posting defamatory things. So it's such a can of worms that I guess maybe if you're in the insurance business, it is an interesting one to explore, but I think for companies that deal with actual content is a terrifying thought.
All right, very good. Question back here.
Yes. Yes, Arthur Frere from Pablette to Margot. So digital trade is an important component of the U.S. International trade economic system. How would Section 230 impact digital trade? Thank you.
I can.
Yes, go ahead, Kate.
Sorry, not to hog
No,
it.
that's all right.
Yeah, right. So it's really interesting because at the same time that Congress is railing on 230 for all of the reasons discussed earlier, many of which contradict themselves, we also see USTR, I think correctly, try to say, what does it take to succeed in foreign markets? And for companies that grew up under 230 and host content, it takes the ability to know that you won't be sued into bankruptcy anytime one user says something another user doesn't like. And I think that, there was a lot of like hay being made during the USMCA days about like putting 230 into USMCA, which is not actually what happened. And that tension really demonstrates how far from the facts the Hill conversation about 230 is. So I think, yes, Engine would love to see 230-like language in every trade agreement. That is proving to be incredibly controversial for reasons that are political and not policy related, I think.
All right, very good. Let me go to another question from the internet. So with respect to state-by-state patchwork of regulations, would you provide thoughts on financial implications regarding maintaining compliance to include like internal training? Thoughts on how Section 230 reforms might impact these? Doug?
I mean, this is Kate's playbook, but I mean, it becomes expensive to stay in compliance simultaneously in lots of different states, and that makes it harder for new entry. It insulates the incumbents from competition, and it's in general a bad phenomenon. And
I think it gets at the same false narrative that we've been talking about. How does internal training help Wikimedia editors? How does internal training help Reddit moderators who are volunteers, right? It acts like when and there are lots of ideas like this, and some of them make sense for some of the companies, and I promise you, many of the large companies have internal training around content moderation, but it acts like the whole internet works in that top-down way, and so much of the internet just doesn't, and I'm not really sure what you get out of things like internal training or transparency reports from a place like Reddit, where it's not Reddit employees making those decisions.
Okay, so we have At least two, okay, two more questions, and I'll have to cut it off. Yes, you first.
Thank you, Steve Del Bianco. The economic analysis that we seem to be missing is to motivate the users of user-generated content to explain their preferences, because so much of this is focused on the costs that the companies and the platforms will incur. And that isn't compelling. After all, they created social media, and if it's expensive, they need to pay the costs. That's what the traditional publishers say all the time. But we haven't yet made it feel real of the warnings that Doug, Kate, and Sarah have been giving. We haven't made it feel real that consumers will lose a platform to share their news and views if it becomes too expensive to host their stuff. How do we make that more apparent to Americans?
So maybe this is a moment for me to plug. In addition to the brief that Engine signed on to in Gonzalez, we, through our creator work, organized a brief with 18 internet creators discussing the value of 230 and recommendations to YouTubers, Instagram creators, folks on Patreon, et cetera. And it's a really wide range of signers, including like doctors and musicians and comedians, entertainers. And I think they do a really compelling job explaining in their own words how the internet has democratized opportunity for them, because before YouTube, before Patreon, before blogs, before social media, if you wanted a TV show or a radio show or a book published, you had to go to a very small handful of very large companies who have their own opinions about the internet now. And now they're able to just get this content out there and build an audience with almost no friction. And so I think from the creator side, we certainly see that as being very compelling, and that's why we organized the brief. But yes, certainly there's a much larger user pool than just creators, and would encourage other groups besides those focused on entrepreneurship to take up that angle.
So it's a question of public education, and how can you effectively communicate on a large scale? And I'll just point it out, in my view, the teachable moments in the United States are elections, and they are when one candidate says, well, I'm going to regulate this, that, and the other stands up and says, no, the way this works is this, and we get people who can defend the Section 230 regime, explain how it's made publishing your book possible, makes my son's science fiction novels available to people that otherwise would not be available to, and really sells that message on a broader scale. That is one of the ways we learn in this country, is we pay attention in the policy debates and campaigns.
Right, last question.
I'm Kathy Preby. I'm a private equity investor in both equity and debt. Question about regulation. What we're seeing in our community, in our investment community, is that the startup community is leaving the Bay Area, and they're flooding into areas like Texas, Florida, and some of the Midwest. As regulation comes into these states, as the states create this patchwork, what will be the net effect in your opinion? In other words, where will the enthusiasm for starting these companies come from, and where will it be?
Well, I think it's going to depend on, it's in the hands of the state legislatures. I've always been baffled by California, whose every move seems to be designed to build a better Utah. And I just, that's how they behave. And so other states are benefiting from that. And the question is, will they be disciplined enough to keep a light touch regulatory framework that had attracted those startups to begin with, can attract more in the future, and take advantage of the dynamism? Or are they going to get, sort of fooled and think these are the existing firms? Let's go take the money, and that's the real issue at the state level.
Okay.
It's also worth noting that the startup ecosystem includes a lot of companies, many of whom don't care about 230 because they don't host content, right? Like we have hardware companies in our network who probably disagree with me on 230 because they don't need it. So I think looking at the startup ecosystem is much broader than looking at the 230 reliant startup ecosystem. But I know from talking to founders, especially those that rely on 230, there's so many factors that go into where they're located and where they're doing their hiring. And it's things like state tax incentives and employment laws, to Doug's point, like California's treatment of independent contractors is mind-boggling to anyone who's ever seen how a startup has to cobble together a network of independent contractors to exist. So things like that aren't tech policy, but are kind of what we would call entrepreneurship policy, are probably equally as important, recognizing that a startup's users aren't going to be in that state anyway. And so you could have a world where you have, you're based wherever is most advantageous for your company, but you have Utah users, and now you have to follow Utah's law on social media, so it doesn't even really matter where you're based for that purpose.
All right, very good. Sarah, any final words?
No, we could talk about this for many, many days.
It's all been said. All right, well, join me in thanking our panelists, please.
Until the batteries die. So thank you for making that all. We want to make sure we made it through the entire group with all of our new mics. So that's great. So thank you for sticking with us. We're now on to panel 3. I know I have learned a lot in today's discussion. With us this morning, we have Quinta Jurek. She is a fellow at the Governance Studies at Brookings Institute, where she's also the senior editor of Lawfare and previously the managing editor and contributing writer to The Atlantic. Quinta also hosts a really good podcast at Lawfare that's one of my favorites. I mean, she just has amazing guests, and they always kind of get right to the nugget of something and stick with it until you understand it, and I appreciate that. Latif Matima is a professor at the professor of law at Howard University, the School of Law, and he's also the founder and director of the Institute for Intellectual Property and Social Justice. He has testified many times before Congress in support of IIPSJ. We have a new acronym this morning. Thank you, Latif. We don't have enough of those in our lives. For advocacy for socially just access, inclusion, and employment through the IP system. Next to him, we have Baron Soka, who is the president of Tech Freedom. Tech Freedom is known for digging deep into hard into policy and legal questions raised by technological change, and we all know that we love having those conversations with Baron. Previously, he was a senior fellow and director of the Center of Internet Freedom at Progress and Freedom Foundation. And at the end of our days here, we have Christian Stout. Thank you for coming in all the way from New Jersey. He's at the International Center for Law and Economics. He's the director of innovation policy and is an expert in intellectual property, antitrust, telecommunications, and internet governance. Christian has been a fellow at the Internet Law and Policy Foundry as well. as an Eagleton Institute of Politics. Before practicing law, Kristen worked in technology entrepreneur as a lecturer in computer science and department at Rutgers. And I always love doing things with Kristen because he can switch from like the legal side of things to the engineering, which is basically that won't work. You're like, that's always good to have somebody on the panel who knows that. So the key part to this panel is getting to kind of the key question here is we have a lot of people discussing what they think about these laws, but we need to think about what it is that we really think we should fix or amend. And part of this, for those of you in the room, and then we will be posting this on our website, Barron mentioned there was a group that got together in 2019 when we were doing prep on this, and they put together a piece that says liability for user-generated content, principles for lawmakers on July 11th of 2019. And I was like, he was like, he had this little jewel in the jewel box that he'd been hiding this whole time. I was like, why did we not find this earlier? So those of you in the room, it is on your by your table, it's on the tables if you wish to read it. But there's a lot of really interesting points that we're going to get to on this today. So let's start with how should we be thinking about Section 230 after hearing about Supreme Court cases, the economic implications, and what happens if we change the statute? Let's live in the fear level on this. So I'm just going to start here, Quinta, with you. Like, what is it that we should fear most if this changes not in a way that makes us happy?
Sure, absolutely, and it's great to be with you all. Is the mic working?
Yep, I think so.
Perfect,
Yes,
beautiful. Yeah, I think that it's important to understand, as we talked about in the last panel, that a lot of the harm that would be experienced if 230 were to change and to change in a way that wasn't thoughtful and tailored would be borne not just by platforms but by users, people who suddenly would discover that they could no longer have their posts widely distributed. That material that they have come to kind of expect would be available online is no longer there. And we have a really strong empirical example of what happens under these circumstances, and that's Sesta FOSTA, the anti-sex trafficking law that was passed and signed into law in 2018. What we've seen in the aftermath of that law, which carved out changes to liability protections in ways that I think were less than clear and led to a lot of uncertainty on the part of platforms, is that platforms decided that they were largely going to clamp down more aggressively on content that seemed like it could potentially fall into that new carve-out from Section 230. And as a result, a lot of material disappeared from the internet. That's not only a harm in terms of, the ability of the internet to serve as a open and robust place for discourse and free speech, but it also had real material harms to people. In particular, sex workers who often found that resources that they had used to stay safe were no longer available, were forced to work under conditions that were unsafe. And it's difficult to find empirical data on this just because of the nature of the work involved, but we have a lot of qualitative studies and reporting that suggests that people really were materially and sometimes physically harmed because they had lost access to online resources that they had relied on. And so that's just one example. It's, I think, a particularly useful and important test case to keep in mind. And it's a really strong example of how changes to Section 230, even if they're made with the best of intentions, right? This was an anti-sex trafficking statute. It was aimed to, protect children from real predation, can have unexpected effects and can cause serious harms, not just for speech, but for the way that people live their lives and use the internet. And I think that that's important to keep in mind.
Steve?
So is this?
Can you? I think I don't know if it's on or not. Try that again. Up.
Okay. Did it?
Yeah. Okay. They'll just.
As usual, I break tech. Just put it in my hands and it'll deconstruct. So I'm old enough to remember the days in which there was virtually no forum for the average person to speak and to get their thoughts and their ideas out to the public and folks in general. Those were the days when there were only 3 major networks. The opportunity for the average person to have their little voice on the editorial, that was usually around 2:30 in the morning, to say, well, I'm Joe Blow, and here's what I think about the latest thing that this network or somebody else had just done, which meant that nobody ever had any exposure. For print, for newspapers, where did you have your chance to stand up and speak in the public square? It was usually on the letters to the editor page, somewhere that was a half a page or less in the middle of the newspaper. What the internet, through Section 230, has done, it has now created a space that basically democratizes the marketplace of ideas. You know, we place a lot of emphasis on the fact that, oh, is it like that? Is that better? Wow, that's a lot better. You know, we place a lot of emphasis on the fact that, you know, the positive impact that Section 230 has had on marginalized voices. But it's not just marginalized voices, it's everybody, right? Every citizen in America now has the opportunity to opine on just about anything, and it has brought the benefits of the First Amendment into reality. So when we think about what Section 230 has done, it's great, it's beneficial to think about its impact on, quote, marginalized communities, outsider voices, and remember, this includes not what you would traditionally think about as outsider, right? Rural communities, right? Artistic communities, right? But virtually everyone. And if we break Section 230, the way that I have a tendency to break mics, all of that goes away. And we go back to a situation in which you basically have a very tiny portion of mainstream America, a very tiny portion that controls the public conversation.
Barry.
I would emphasize 3 points, which you'll see in here essentially distilled. Number one, this isn't Europe. It's really, really hard in the United States to distinguish what is lawful from what is unlawful. And that's not merely because our laws are more limited than Europe. It's because, of course, the First Amendment heavily restricts what is unlawful. And if you want very concrete examples of that, I would point you to the brief that we at Tech Freedom filed when the Fifth Circuit law, which was upheld, excuse me, the Texas law, which was upheld by the Fifth Circuit, that law would ban viewpoint discrimination. It was very clear that the judges really didn't understand what the law did. Texas said over and over, don't worry about all this problematic content because we have an exception in the law that allows you as a platform to moderate content so long as that content is unlawful. So we filed a brief at the Supreme Court explaining why we needed the court to step in and grant emergency relief to stay the law during litigation, which the court did. And our brief explained just what kinds of content would actually be allowed to flourish if the law went into effect. And that includes things that everyone in this room would be simply horrified by. If you've ever read the cases, for example, on incitement to suicide, you'll have some idea of just how far you can go in this country before you cross a legal line. And most people just assume that that line would be crossed much earlier than it is. So point number one, very, very difficult to distinguish what is lawful from what is unlawful. And what is unlawful is very, very limited in this country. Point number two, as we say here in this document, Section 230 has never done anything to prevent the people who actually create content from being held responsible for it. Period. End of story. And that should be the case, should remain the case. The question is, what should platforms be held liable for? And you heard earlier that today, Section 230 does allow platforms to be held liable when they help to create content, and also has a number of important exceptions, such as federal criminal law. So you're a platform, you're never immune from federal criminal law under Section 230. And then finally, and this is really the key point here that's embedded in this Principle 6 under innovation, the work that Section 230 does ultimately is in making it possible to build systems like we have today to offer content at scale in the US legal system. Many people say, oh, but it's no big deal. We could just amend Section 230 because other countries don't have this sort of framework. Well, that's true, but they also don't have our legal system. You've heard a little about this, but I would just reiterate that this country is unique in the Western world for not having a loser pay rules. That means that in other countries, when you bring a lawsuit and your lawsuit fails, you end up getting stuck paying the cost of litigation. That serves as a huge deterrent to bringing frivolous suits. The United States and Canada, in many ways, are the closest comparison, but the US has 15 times more lawyers per capita than Canada. Gives you some idea of how different our legal systems are. Section 230 works by making it possible to host content at scale under the constraints of the US legal system, and in particular under the perverse incentives that the common law rules that we had in this country created. And it's not just the one that you've heard so much about today, the 1995 case that said if you remove some content, you become more liable for the content that you didn't remove. That would be bad enough. But the baseline law, which remains the law in other countries, is that you could be held liable as a distributor, which means if you have reason to know of unlawful content, then you can be held liable. Now, there might be ways in some narrow circumstances to provide some notification that content has been adjudged to be unlawful. But if you don't create that kind of a very carefully crafted notice and takedown regime, and I'm sure we'll talk about this more, and you instead just have a general if you should have known about it rule, which is the baseline rule for say, booksellers in this country, then what you create is another version of the moderator's dilemma. You don't have any incentive to allow people to report unlawful content. In fact, you have a perverse incentive to stick your head in the sand and make sure that nobody can tell you that content is unlawful, because if they do, you'll be held liable for it. That was actually the holding of the 1991 Cubby case, which is usually held up as a win for platforms. The court dismissed the lawsuit in that case only because the plaintiff in that case didn't allege constructive knowledge, but the court said constructive knowledge was the baseline rule. That can't be a workable rule for dealing with content on the internet.
Christian?
Check. Oh, yeah. Oh, okay. So that seems like it's working. It's probably appropriate I'm batting cleanup here because I do think that there probably is some room for reforming Section 230. The problem is that the proposals that are frequently floated about reforming 230 are usually in the wrong direction, in my opinion. So first, I would state that the principles that Barron is pointing to in his lap and on your table, we signed on to those. We think those are the right baseline at ICLE. I agree with that. The problem is that I think that the way 230 has developed over the last several decades, or 2.5 decades, has grown in a way that has made the law more capacious than it necessarily needs to be along some dimensions. And I think you see this with the way some of the case law has tried to develop in a way to deal with harms that arise because of the way internet platforms work, knowing that there is an actual harm that an intermediary is in a position to control. But the way 230 operates makes it difficult for that to happen in the first place. For instance, the Lemon case, where Snapchat, Snap, the company that has Snapchat, they were sued because their service was being used by kids to play a game where they would drive too fast over the speed limit, and theoretically Snap had some control over this. Now 230 protected Snap from the liability under the way 230 has been interpreted. However, the courts were allowed a products liability theory to go forward, and 230 didn't block that. I'm not sure that a products liability theory is the right way to go forward there, but I think what happened is the courts recognized, no, there is a harm that happens here. There is roles for intermediaries to control bad behavior on these platforms, but the way the law is developed has made that difficult. I think a lot of the defenses of 230 are based in well-founded concerns. Barron brings up the amount of lawyers we have in the United States. As a lawyer, I agree. There's probably too many of us. And I do take very seriously the idea that if you created a 230 exception, you repealed 230, or did one of the proposals that are frequently floated, you probably would have a flood of litigation. But that's not to say that any change to 230 will necessarily bury platforms and other online providers in litigation. There needs to be some way to introduce the concept of reasonableness in the moderation standards. It's going to be very difficult. Barron flagged a lot of the ways that this could be difficult. But that's not to say that it's impossible or completely unwarranted. Right now, 230 works as a complete liability shield. There's from secondary liability. There's not very many places in United States law or law of the West where you've seen something like that emerge. And I think the initial instinct of the lawmakers in the 90s probably was right. They weren't sure how this industry was going to develop. They didn't know where the friction points would be, and in order to figure out where these businesses could grow. The internet has given us a tremendous amount of value. But after 2.5 decades, we've seen how attorneys have tried to bring these suits. We've seen the different kinds of harms that can arise. I think it's at least plausible that we want to have a discussion that looks at that. Now, the approach that a lot of parties take to trying to go after 230, I'll touch on the problems with them. They tend to take, like Foster Sesta, a piece-by-piece approach. They want to create narrow exceptions here and there and there, and I think that kind of way of reforming Section 230 likely would do more harm than good. The same token, people who are mad at social media platforms either because they think they've been censored or they think they're not censoring enough, whatever the reason, they want to repeal 230. That would be tremendously damaging to our economy. I don't think that's the right way to go either. Reform would need to be something that would take a long time to implement and would be very marginal, would allow courts to start to look at the reasonableness of how these platforms engage with their users. I think one of the things that points me in the direction of thinking about that is the 230 discussion frequently is something like there's a lot of law in the United States that's really bad, and 230 gives platforms a way around these bad laws. For instance, what Quinta brought up. The problem with the Foster Sesta, apart from the fact that the law itself is not a very well-written law, in my opinion, is that, and the exposure that Quinta noted that people had to not having the ability to have safe ways of transacting sex work online. That's not a 230 problem, that's a sex work law problem. But we're using 230 as a Band-Aid on an aspect of our culture and of our law that is perhaps treating people unfairly. So the answer is not to plug holes in our legal system in different areas by creating a blanket secondary liability immunity. It's to figure out where we need to fix our law and where we can actually work with 230 to figure out where platforms behave reasonably or not. So,
Baron, you seem to disagree in the middle of that. Do you want to comment on that?
Yeah, well, I mean, the Lemon case illustrates that 230 isn't a blanket immunity. It illustrates that you can, in fact, be held liable for your product design. Remember, in that case, the design was the filter that made it possible for kids to record how fast they were going and to compete with each other, which caused their deaths, right? And the court said in that particular instance that the cause of action did not seek to hold the company liable for content at issue, so 230 didn't cover it, right? And that, I mean, that seems like the kind of interpretation that I'm not sure that it's right, but it seems like the kind of thing that is consistent with the structure of Section 230, and we could be having a conversation about those cases and where there's room today, because it's clearly not a blanket immunity. In addition to what I said earlier about the exclusion for criminal liability, right? So it already says that you're not covered if it's federal criminal liability, if you help to create the content of the user, or if the cause of action is doing something other than treating you responsible for content, such as the design of a filter. Now, I also agree with you, we should have a conversation about how Section 230 can be changed. The premise of that document, in fact, was that 230 is not sacrosanct. It could be improved. My basic concern is that we don't have the institutional capacity or seriousness as a country to actually amend statutes in a careful and thoughtful way anymore. And I don't know how we get around that problem, except that when Congress has attempted to address complicated issues like this in the past, internet sales taxation in 2000, modernizing the antitrust laws in the mid-aughts, what it's done again and again has been to create a commission that is full of actual experts that can make a recommendation on what to do about this. If we created a commission like that 4 years ago, it would have completed its work already. And we could have an adult conversation about the things that serious people would propose, having looked at the implications of them in legal practice. And instead, we have the same dumb conversation over and over and over again. And that's not what we're trying to do today, but that conversation or that meta non-conversation is a waste of everybody's time.
Just want to add one thing to what Barron said. So it sounds like Barron actually agrees with me.
We can review the record on that.
Right. Well, so the reason I brought up the Lemon case was because I think it points to people trying to find ways to get at conduct which we would all agree there's something that Snapchat had a role in being involved in controlling. But if you look at other cases, for instance, the arms list case, that a proprietor of the website was protected when users of the website were selling illegal guns, and a gun that was purchased illegally on arms list was used to murder somebody, Section 230 protected arms list. Now, arguably, arms list might have a duty to administer its services in a way that prevented illegal gun sales, you would think, but 230 protected that case. So what I'm pointing to is that there's problems running through the case law in 230 where we need to think seriously, like, look, there is some harms we have discovered that we do want to have platforms have a role in mitigating.
Well, yeah. Well, the part of what you expressed that I would agree with is that there are things that have really nothing to do with Section 230, that have nothing to do with platform liability, that we really should not be trying to fix through Section 230. So the fact that Section 230 doesn't lead to the most perfect of all impacts or results isn't really the issue. If we have other problems in our society that we need to fix, we should fix them with other areas of the law. I think that one of the best illustrations of this is that we need to get back to, well, does Section 230 or did Section 230 accomplish what it was specifically intended to do? It was intended to provide a more diverse set of voices in the public conversation. And I think that anybody can take a look at pre-internet, okay, and what was the diversity of conversation and speech in our society, and then you look at the post-internet, right? So the thing of it is that the first way that we generally evaluate the efficacy of a statute is with respect to the thing that it was intended to do, did it do that? And I don't think there's very much debate as to whether or not Section 230 has accomplished that. We have a wide variety of platforms, we have a wide variety of speech, we have a wide variety of viewpoints available. So from that respect, Section 230 has been a success. So now we move to the next level. And the next level is that, okay, but where the hubbub comes in is that in the second part of C2 is, okay, but we do know that if everybody speaks, sometimes some people are going to act out and not behave right, right? And what do we do about that? And what we've seen is that I think appropriately at the outset, Congress said, well, we don't really know exactly what that's going to look like. So for now, what we're going to do is we're going to reverse the decision in Stratton Oakmart, which was the case that said, if you do anything, okay, that's it, you're in trouble, you're liable. And Congress reasonably said, well, that can't be right, right? I mean, you know, they start hurling chairs out the window, there's liquor being poured out the drain. I mean, all kinds of, there has to be some circumstance in which you do something, right? And so now we've had that paradigm in which platforms can at least do something. And now what we're arguing about is that, the devil in the details. Do we like the way that platforms are doing something? Is there something more platforms can do? And I think you're right, both of you are right. Okay, now's the time to begin to have that type of a conversation as to how do we tackle that. And it looks like we may not have a choice, right? It looks like forces are getting to the point that that conversation is going to have to be had, and maybe that's where we are today to begin trying to shape that conversation.
Great, thanks. So we know that we have policymakers that are about ready to introduce legislation, again, that is not, not really in the sweet spot of where we think the answer should just be. Two things I always think of is you have one group that are like, it's a lawless frontier, and the other group is like, you're not hearing me. So, how do we get in between the ones that want to figure out how to slice and dice Section 230 into solving a lot of problems, which you've pointed out it really wasn't meant to be there for, and the other group that is convinced that if we do anything, that every voice of anger and frustration is going to be muted. So what do we tell the lawmakers that are coming back back in session soon and are going to be dropping this legislation? What's some guidance you would give them?
That's
You first.
Yeah. That is the question. I think it's really, really difficult, and I think somewhat ironically, it's a difficult question precisely because of the conditions that have led so many people to want to take a hard look at 230 and reconsider it, which as Christian points out, there are a lot of underlying societal problems that have come to the surface in recent years. There's a lot of discussion about the healthiness of our civic dialogue. And for the same reasons that causes people to take a hard look at online platforms and say, is this the civic discourse we want? That means that lawmakers are operating under a set of incentives that perhaps are not best aligned with producing serious policy. And I think that makes this conversation really, really difficult. I will say, I generally don't think of myself as an optimistic person, but I will say I think we have maybe made at least a little bit of progress. Barron can tell me if I'm wrong, on the nuance about our sort of collective thinking about Section 230. I mean, if you look at some of the legislation that was introduced when 230 sort of first hit the spotlight in 2018, it's on the level of get rid of it, repeal it. Both President Biden and President Trump indicated that was their desired policy during the 2020 presidential campaign. Now, certainly, as you say, Shane, there's been a lot of legislation introduced in Congress taking different approaches to 230. I disagree with most of it for all of the reasons that we've set out here. But I do think you start to see at least a little more sophistication in the approach that lawmakers are taking and acknowledging in some cases that perhaps we might want to ensure that platforms that perform different services or are different sizes, however we want to evaluate size, have different obligations under Section 230, thinking about specific aspects of platform performance. In the case of legislation like the Platform Accountability and Transparency Act, tying 230 to transparency obligations. We can debate, whether or not those different pieces of legislation are perfect, and I don't think they are, but at least it seems to me that we're moving toward a little bit of more sophistication there. I will also say, it's anyone's guess what the Supreme Court will do in Gonzalez. I was really cheered by the care and sophistication with which the justices clearly had thought about these issues, including Justice Thomas, who's been a really strong critic of 230 in the past. And so, I certainly don't want to say that this means that we're on a path to a good solution, but it does seem to me that maybe just as a result of, this issue having been in the spotlight for a while and all of us, yelling and screaming about the fact that we need more sophistication, that maybe at least a little progress has been made.
Some of what you've said, I think, is not progress. The idea, for example, that we should just slice and dice 230 for different size companies and impose different obligations on them, or use Section 230 to coerce companies to do things, I think is not progress, and that's in the sense that's contrary to what we, when we all sat down in 2019 to try to agree on what reform ought to look like. I think we agreed those would not be good things. So I don't think that's great. I think the bigger problem here is you have been more diplomatic than I think we should be about the political dynamics at work here. The reality of this is very simple. If you applied a rule neutrally about whatever, misinformation, hate speech, incitement, pick your category. If you applied that rule neutrally, if you had a computer do it, if we sat down and had, pure engineers come up with that rule and there were no human intervention at all, however you want to define neutral application of the rule, it would produce disparate impact along partisan lines. It is that simple. You would wind up in a situation, no matter how you did that, where the companies would seem to be discriminating. And it couldn't possibly be that this reflects a difference in the American population. No, it has to be because the companies are biased. And the companies themselves are unwilling to actually explain that the problem is not them, it's users. That's the problem, right? And until we can get around that dynamic, one of our major political parties will continue to beat the drum on the culture war and make this one of its top 3 talking points, that tech is out to get you and Section 230 is the problem. And that, in a nutshell, is why we will not have a serious conversation about this issue.
So I was going to say I'm very cynical, but Quint actually made me feel pretty positive, and then Baron made me feel sad again. So I think I'm in the middle somewhere. And I'll extrapolate from what Baron said. The problem is not just users, it's humans. If you've ever met any humans, they can be horrible people sometimes. So we're filled in this sea of people doing terrible things, including politicians. And one of the things that leads me to be slightly cynical is the public choice and political economy aspects that drive politicians' decision-making. As Baron noted, I think both parties, but definitely Republicans, I think there's some problems on the Democrat side too. The interest is in making noise that helps with fundraising. It's not necessarily in talking about hard problems and thinking about marginal fixes that will move us forward an inch at a time. I think, like, as I said in my opening comments, I do think that there's room for reform. I think the reform should be boring. It should be something that boring people on boring committees, they review cases, they review instances of problems, and then they think about how we move that ball forward very slightly to the point where normal average citizens might not even recognize that there's like incremental changes happening. And it's really just to figure out, like, well, we know it's highly unlikely that we had, the wisdom of the ancients came down in the 90s and gave us the most perfect law that possibly could exist. We know there's probably ways to fix it. But the ways to fix it is not going to be things that enables you to send fundraising emails saying, can you believe this, can you believe that? You better donate to my campaign. So how do you talk to people in that environment? I don't know. I think doing things like this probably helps to some extent. I think, writing papers. So like Jeff Manny and Ben Sperry and I wrote a paper thinking about these problems, and like we came up with like a possible way we might want to recommend a solution. I think everybody should try to do things like that, and then talk to staffers, talk to people in the regulatory agencies, and just, you have to advocate for sanity in these proceedings. And I recognize that is very difficult to do, but there's no other fight to be had.
Well, let me give you another layer of cynicism. So Christian and Jeff and Ben have made a really good faith effort to try to tweak Section 230 in the technocratic way that he's just described. So they, I think, improved upon a pre-existing proposal that was made by Professor Daniel Citron and Ben Wittes, which would have said that when you're sued, you have to show the reasonableness of your content moderation practices. It should be pretty obvious that that is a radical change to the statute, because every litigation would have as a question of fact whether the content moderation practices were reasonable. And understanding that, I suppose, the proposal that Christian and his colleagues have come up with would try to solve that problem by saying, well, that's not workable, so let's have a certification of the reasonableness of content moderation practices, and it's only for unlawful practices, right? So I think I've fairly...
Like defamation, essentially, you always get 230, and it would be, if you identified some sort of like substantial real world harm that would be illicit, then yeah.
So I think that's a serious proposal, and it's not unreasonable, and we should have a conversation about it. One problem is that we can't have a conversation about it. Another problem is that even if that were implemented, note that what it does is kick the difficult question of assessing reasonableness to the regulator. Well, we already know how that's going to play out. Imagine what the Trump Federal Trade Commission would do with the authority to decide whether your content moderation practices were reasonable. Now, again, it's only for unlawful content. I get that. But we know that with that sort of weapon, which is effectively the ability to shut down a business, it's denying someone their moderation certification, that is effectively a licensing regime. And that I don't see why that in practice would work any differently from the way that, say, merger review or license review does at the FCC, where the regulator has the ability to just hold up certification and until it can extract what it wants from a company. And that's exactly what these companies have been subject to today. For all that Republicans scream and cry about jawboning, they're the ones doing it. They have, for years, been putting pressure on these large tech companies not to apply their moderation practices in a neutral manner because it produces, again, disparate impact. So the companies have bent over backwards not to apply their content moderation practices consistently or even to change their rules to avoid seeming mean to Republicans and to avoid being criticized by them. So I fear that simply adding a certification regime to this system simply gives them a legal weapon to do what they're already doing.
So getting back to like sort of the core of your question, if we were sitting down with a bunch of legislators and they said, okay, how do we start this thing, right? The first thing I would do is I would say, okay, remember to adhere to the dichotomy in the statute itself. The statute does two specific things. First thing, it says, let's make it possible for platforms to exist, right? In other words, the problem with the Stratton, Oatmark, and Cubby cases was that just offering the service, just saying, hey, listen, you've got something to say, here's a marketplace, you can say it, right? Just doing that, you incurred the risk of liability. So the first part of Section C of 230 says, no, if you provide the service and that's all you do, that's fine. You're not going to be treated as a publisher, et cetera, what was talked about earlier. So let's make certain that we don't fix that part of the statute because everything indicates that that part of the statute is not broke. We have a multiplicity of platforms, and really no one is saying we ought to get rid of social media altogether, right? Everybody likes the fact that there are platforms out there. So then I would say, okay, now what you really want to do is you want to take a look at the second part of the statute that talks about content moderation. And what everybody's arguing about is, okay, is that being done the right way? And as was discussed earlier, there's one side of the room that says it's not being done the right way because you are discriminating against us. And the other side of the room says it's not being done the right way because you aren't going after enough bad guys. So clearly that's where the problem is. It's about the content moderation part. And again, being at the very beginning of it, saying, okay, you want to know what you should do about that piece. I think we need to get back to focusing on two particular things, which are the very most difficult things about content moderation. One, what type of content is it that you want to focus on? That's difficult. And two, who is it that you want to do this, right? And that's where the problems lie, right? Do we really want the ISPs to carry the load? I can't speak for an ISP, but if I were an ISP, I would really not want to do this. I would really rather that there was some specific statute, somebody else, that they did it, that they moved it, and I had no responsibility whatsoever, okay? But if we want to focus in on what type of content and who does it, okay, let's look at that. And I would, as has been said a couple of times earlier today in other panels and today, I would embrace a more iterative process. I would not try to spoon the ocean in the next round of amendment right now and to say that any and all types of content that could possibly be offensive, we have got to figure out how to deal with that. This is America. We have the First Amendment. We have a multiplicity of viewpoints. I would start by focusing on something really, really narrow, like, for example, patently criminal conduct, right? If I put up something that says, looking for hitman, call me at X, Y, that type of stuff, right? Okay. I realize that some people don't think that's a good idea to do it piecemeal. And normally one would say, let's not do things piecemeal. But again, this is America, right? It's very difficult to look at a bunch of content and say, what's good, what's bad. So I would start there really, really very narrow. And then two, I would copy or try to emulate another statute that tries to deal with content on the internet. It was mentioned a couple of times earlier today. Again, reminding us that Section 330 is not intended to do everything. The DMCA, that's intended to deal with intellectual property content, specifically copyright content. And what that does is that you have this notice and takedown mechanism that ping pongs back and forth between, I think it ought to come down, no, I think it ought to come up. And then very quickly in the process, it's out of the hands of the ISP, right? And again, I can't speak for ISPs, but if I were the ISP, I would prefer that I have no liability, I have no respect. Look, somebody else, right? It's ping pong back and forth. The two sides that are complaining as to whether or not this content ought to stay up or come down, they can't make a decision. Okay, somebody else other than me is going to sit down and resolve both. Does it stay up while we are resolving the dispute? And then ultimately, what happens to the content on a permanent basis?
We're coming up on time, and I have one more question I know that we wanted to get to, which is step into the next world of Web3 and ChatGPT and all the learning language models we have coming up, and so as we're thinking about what we're dealing with in the current environment, we have a whole new tranche of things coming at us, which are hallucinations, things that are going on online, and the ability to have liability around that. Do we want to attempt to address that as we're going into this world, or as you're talking about, is this a piecemeal environment that we should be thinking about?
Can I just respond quickly to Lateef? So I think the comparison to copyright is actually really helpful because there are certain areas of commonality, but they're different in some pretty significant ways. I mean, in one important respect, in the context of copyright, the interactive computer service provider can just say, look, this is not my problem, or this can stay up, or this can stay down, or someone else can sort it out. That's not generally the case for content moderation. Content is coming down because the platform needs to be able to enforce its terms of service to create the community that it's cultivating, because users don't want to be associated with that content. Advertisers don't want to show their product ads near that content. It can't just stay up. It's got to come down, and the people who are responsible for it have to be removed. And if you judicialize that process in the way that copyright sort of does, it doesn't work for essentially the same reasons that you don't judicialize, the bouncer at the bar or the person who is responsible for maintaining decorum in a room, except at the scale of billions of users. So they're radically different things. I would come back to what I said at the outset about the difficulty of identifying what is, to use Lateef's term, patently unlawful. I mean, in copyright, maybe we can do that because we can fingerprint content, and you can have a workable system like Content ID where YouTube knows what to take down. There are very few areas where we could do that. I mean, child sexual abuse material is one, and yet there we actually don't even have exactly an affirmative obligation to look for it. If you find it, you have to take it down. But that's not worth getting into for now, but suffice it to say that if there were other areas of content where you could identify that it was unlawful, that's what I meant when I said earlier, I would be okay with a notice and takedown system for that. That's not going to work for 99% of the content that we're talking about here. So we have to figure out what to do with that. And to the question of how the statute works, it's yes, you have described the goal of the statute. The statute has those two goals. The problem is they don't map neatly onto the two core provisions of the statute. I mean, C2A, yes, is only about content moderation, but almost all content moderation cases are decided under C1, which says you're not to be held liable as a publisher, because that has been interpreted, rightly in my view, and in the view of every court that's looked at this, to include not just the putting up of material, but the decision about whether to take it down. And that's why we can't just split these conversations and try to have a neat, clean conversation about content moderation. And then one final point, if we did, we would still have to make sure that the law was content neutral. That's what the First Amendment requires. So one reason that we know that what the Trump administration wanted to do in this respect would not be constitutional is they wanted to say, oh, only C2A should protect content moderation, and it should only protect certain kinds of content moderation, that is, the categories that are specifically enumerated. If that's how the statute worked, it would be unconstitutional. It would provide an aid to the removal of certain kinds of content, but not others. That is called content-based discrimination. The fact that the statute has not been interpreted in that way, either in C2A or in C1, the publisher provision, is why the statute has not been struck down as unconstitutional, because it protects the editorial discretion of platforms, broadly speaking, without discrimination on the basis of content.
Yes.
I'm happy to answer your actual question if you want.
Yes, please.
Okay. So the problem that I think you're flagging, Shane, is something that happens with, you can think about it in terms of Tesla and auto driving cars as well, right? So if Tesla creates a car that's now fully capable of self-drive, and someone gets in an accident, who's responsible if the person behind the wheel wasn't the one operating it? Is Tesla somehow responsible even though no one at Tesla was operating it? In those cases, one of the things I've been thinking about is, well, probably you want to say the liability would rest with the manufacturer, and at the same time, you would rely on an insurance system to back up the kind of harms that would arise from that. I think the same thing would happen with things like large language models and different kinds of AI. They're going to be able to generate some horribly offensive and possibly dangerous content. The users who click the button to generate them, I don't think would be responsible. I don't think necessarily even the website that hosts it. I would think it would be something like the developer. Now this gets complicated when it's open source, but say something like the developer. And going back to what we heard in the last panel, that there's a developing market for insurance in the privacy space, which is a mess right now. 230, to some extent, staved off the development of a fully robust insurance market for platforms because of the way it operates, because you frankly didn't need it, so that market didn't develop. But what would happen is if 230 was changed to allow some of the negative externalities that these platforms generate to now redound to the liability of the platforms, ideally you would have insurance markets that start to develop to handle some of those things.
So I'm just going to go to last comments by anybody to just close out the panel, because we are right at a little past the hour.
Sorry, everybody.
Any last thoughts? No, it was a very dynamic conversation all the whole day.
Well, on that last point, there's a reason why Microsoft and Google, and only Microsoft and Google, are developing these tools, because 230 currently doesn't protect the platform when it develops content. And to the extent that's what these services are doing, they're not protected, and it's only the very largest companies out there that have the resources to be able to survive litigation over that content. And I think there's an important lesson there for the other services that we're talking about. I think the most important point made on the last panel was the discussion of a service like Wikipedia. Right? Wikipedia is, legally speaking, is indistinguishable from the large platforms. It needs 230 more than anybody to survive.
I think the only last thing I would say is that, obviously conversations like this, when we leave the room, we don't all walk out and say, oh, that's it, it's solved, right? But I think one of the great benefits of this conversation is that what it does do for us, and hopefully for the public at large, I don't think the public at large has had the opportunity to appreciate the benefit of Section 230, right? That one, the multiplicity of platforms it has enabled, and two, how complex, what a morass this situation is. And that if we were to deconstruct 230, think of the Pandora's box that we would be opening. So if nothing else, this helps us to understand, okay, just what it is that Section 230 does in the first place. And then secondly, if we're going to try to, quote, fix anything, we've got to be very, 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 very careful, because once you open this up, as the entire program today has demonstrated, this ain't an easy thing to figure out.
Yeah, I'll just close by pointing again to the generative AI point. If I'm correct, I believe that OpenAI is already fielding lawsuits in Germany and Australia for folks who say that the ChatGPT defamed them. There was an article recently in the Washington Post about fake sexual harassment allegation that it produced about Professor Jonathan Turley. So I would certainly imagine that we will be seeing some litigation in this space sooner rather than later, and we may well get some answers provided to us by the courts about what direction this will go.
Oh, good. We have more to talk about. Okay, well, thank you all for your time and attention today. As you know, this is a very difficult topic that we've been working on for a long time. It's very important because if we get it right, it will continue to let the internet go. If we get it wrong, we'll all have hell to pay. So thank you, and please join me in thanking our last panel.